the course with regard to the polity module. Well, just take 5 to 10 minutes and then we will proceed with the coverage of the topics. All right. So, before that, I just wanted to know how many of you in this class has done foundation. You are all done with the foundation. Most of you are done with the foundation. Okay. So, this could be really beneficial for the students who are focusing upon prelims 2025 and who have had some kind of foundational knowledge, because it is not a basic course. This is something that is going to build on, and a very focused preparation is what we are trying to do in this particular class, where we will try to connect all the critical gaps in your understanding. We will try to do a lot of questions so that the application becomes easier for you. That is the idea. So, let me just take 5 to 10 minutes as to how we are going to orient this particular class, what is the objective of this particular class. So, the idea is that we are planning to get at least 80 to 90% of the questions. We cannot focus on all the 100% of the questions, that is beyond the control, and if you focus that we will have to get all the 100 questions right or the 100% of the questions right, then I would say that is not a right approach. Uh, because all that you need, how much marks you need to clear your prelims examination, you just need 50% of the marks. I think the last 10-15 years UPSC cutoff has never crossed 50%. So, wherever it is possible you try to maximize, wherever is your, say let us assume your conventional areas are there, you should focus upon say 80% of the questions you should get it right, then automatically you will clear the prelims examination. So, my idea here is also to make sure with the limited time that you have got, we have got around 40 to 45 hours probably to complete this entire module. So, my idea is make sure that you get 80% of the questions right, that is coming from the polity. Say every year 15 questions are coming in polity. So, we will make sure around 13 to 14 questions you are getting it right. We are not concerned about probably one question, one or two questions which may come from various miscellaneous areas. So, that is not our focus. Our focus is getting 80% of the questions right. So, how I am planning this is I will do in every class, or probably as we will proceed, we will take it by theme by theme. So, I will take up one particular theme, we will make sure that the entire concepts in that particular theme is covered, and then we will also do a lot of practice questions and the previous year questions. I am planning to do the last 15 years of previous year questions from everything. So, the idea is the last 10 years will tell you how the trend is. So, probably I will go back another 5 years also. So, that we will make sure that from that particular theme certain practice questions which are almost simulated on lines of the previous year questions is also done, and then we are also doing the previous year questions. First we will cover the concepts. So, what are the themes that I am going to, and what is the order that I wanted to do all these things, I will give you the orders also. So, probably if you want you can read those things today. Of course, you may not have read, but maybe from tomorrow if you want to read, you can read before coming to the class if you want. So, I wouldn't say it is mandatory, but if you want to do it you can do it. Okay. So, what are the topics or what are the themes to be covered? So, this is the order in which I am going to cover the theme. So, online students, good morning to all of you. I hope it is audible to everyone. So, please give me a confirmation, online students, the students who are live in YouTube. So, can you hear it? All right. Okay, the first theme that I am going to talk is about the executives. So, this is the first theme that I am going to cover. So, when I talk of executives, all these topics will be covered under this. But as you understand, this program is basically prelim centric. So, it will be covering from the prelims point of view. So, where I will cover the topic of president, vice president, PM and the council of ministers, and then you have the governor, CM and the council of ministers, and then you have the attorney general. Please put your mobiles in silent mode. Attorney general and the advocate general. all these topics will be covered. So one single go will cover all these topics once your executive is done. And you can expect, if you see the UPSC previous attempt, 1 or 2 questions are asked from this particular topic. So this is the first thing that I am going to take. And then once I complete this particular theme, I will move on to the legislature. So in legislature, there are 2 parts. One is I'll take the parliament, and almost the same replica of parliament will be there in the state legislature as well. So once this is done, your entire topic will be done with regard to the legislature. So if you see the legislature where UPSC is usually focusing, we'll touch upon everything. But even in that, if you see the concentrated areas where UPSC has been repeatedly asking questions, they're asking question from the composition with regard to parliament and state legislature. Then they ask question from qualifications and disqualification. The role of presiding officers very, very important. So when I say presiding officers of both the houses, questions related to that. Parliamentary privileges, and then you have topics like parliamentary procedure, parliamentary procedure, and then you have topics like, once you are done with parliamentary procedure, legislative process, which includes the various types of bills. Questions do come from questions like areas like money bills, constitutional amendment bills. So this will all be part of the legislative procedure. And then of course the budget. So you can also expect one question from budget. And then of course another important topic is the parliamentary committees. Alright, so these are all the topics that I am going to cover. So which will almost cover everything that is there in your Lakshmikant book, but probably I will follow a different standards when I will go through it. I will follow a different order when I cover all these things. Do you know how many questions does come from the legislature part every year? Last year you can see a lot of questions have come. So on an average, do you know how many questions you can expect from the legislature part? Minimum I would say 2 to 3 questions. Minimum I would say 3 questions. I am putting it in a very, I would say, in a diluted manner. Minimum 2 to 3 questions you can expect. And then once I am done, a similar thing I will also cover with regard to the state legislature. Only thing is there are few differences when it comes to state legislature. So we'll try to know those differences. Now once I am done with this, I'll move to what is called as judiciary. So where I'll cover all the things with regard to the judiciary, right from the constitution of the different types of courts, their appointment process, their powers and functions. This is where UPSC usually ask a question. And then once I'm done with all the three important themes, then I'll go to what is called as the philosophical part. So this is the order that I'm going to do. The philosophical part in the constitution, which includes topic like preamble, fundamental rights, DPSP, fundamental duties, and of course, in addition to that, I'll also do these two things also: union territories, union and its, sorry, union and its territories, plus I'll also do citizenship. These will be the first 4 themes. In addition to that, I'll touch upon the Constituent Assembly also. Here very briefly, I'll touch upon those things, whatever is relevant for the examination. So 4 major themes that I have covered: executives, legislature, judiciary, and then in philosophical part, I'm going to combine all these areas, which includes preamble, fundamental rights, DPSP, fundamental duties, union and its territories, sorry, union and its territories, and citizenship. Okay, these are the first 4 themes that I'm going to cover. Can anyone tell me how many questions you can expect from these 4 themes of the overall questions? Say let us assume 15 questions are going to be there from polity. on an average. This is what UPSC has been asking. Out of those 15 questions, how many questions can you expect from these areas? How many questions? 10? We cannot predict the exact number, but can you say in terms of the percentage, probably out of say 15 questions are equated to 100%, how many questions can you expect from these areas? What percentage? Around 60 to 70% of your questions are going to be from only from these themes. So that is how we will have to segregate the areas and we will have to see what is very important. 60 to 70% of your questions, along with this, I will touch upon the relevant current affairs also. So for example, I will ask you one question. Say for example, does the governor and the president under the constitution, do they have any constitutional immunity with regard to the criminal charges? Do they have constitutional immunity? So there is a current development related to that. So whenever I discuss such topic, I will touch upon the current affairs also, the relevant areas as we will proceed further. So these 4 areas is going to take us some time, but it doesn't mean that I am not going to touch upon the other areas, but your 60 to 70% of the question is going to roughly come from this particular area. So once I am done with that, then I will go to the center state relationship. So remaining things are very small topics in relation to the first 4 things. So center state relationship, you may expect one question, not more than one question probably if it comes. And then local bodies, yes, probably you may expect one question from local bodies. So this would be our 6th theme. So once I am done with local bodies, then I will go to constitutional bodies. You may expect one question from here also. Constitutional bodies is another important area. So you have done center state relationship, local bodies, constitutional bodies. Now once I am done with all these things, then I will take up another important, okay. So along with that, so 7 themes I have covered. So come to the next thing. Okay, if you want to make a note, just make a note of it very quickly. Done. So 7 important themes, but first 4 things are very important. And then the next thing that I will do is the emergency topic or the emergency provisions. So everything in your text will be covered, but in this order it will be covered. Emergency provisions, you may expect one question. So the 5th theme, 6th theme, 7th theme, 8th theme, these are all areas, maybe you can expect one question, not more than that. And then the next theme is again very important, is important political concepts. This is UPSC is giving a lot of importance these days. So this is, I would say, very important, because you may expect 1 or 2 questions especially from this particular topic, which includes concepts say like equality, the concept of justice, secularism, parliamentary democracy, constitutionalism, etc. So we will touch upon the other areas also. So this has become very important today, because UPSC is every year at least asking one question, maybe it may go more than one question also. So this also I will touch as we will proceed. And then the next important theme is important articles. I will touch upon 100 important articles. So students ask me, do I have to remember the articles? I would not say you do not have to remember all the articles, but maybe certain important things you may keep in your mind. So important articles I will touch, and then important amendments, this will be one major thing. So if you look into UPSC questions also, every year they are trying to ask one question which will touch upon certain important amendments. So important amendments also I will do. And then I will move to the next area, that is schedules. So UPSC also asks questions from schedules every year. So from the 12 schedules, probably you can expect one question. And then the last theme that I would touch is what is called as the miscellaneous topics. Can anyone guess me what are the things that will be part of the miscellaneous topics? You may expect 1 to 2 questions from the miscellaneous areas also, but that is something that we cannot do it comprehensively, but we will try to touch upon the miscellaneous topics. So what do you, maybe based on whatever we have covered, What can be part of the miscellaneous topics? Say for example, there are questions from topics like Representation of Peoples Act. So sometimes UPSC asks questions from RPA. So I'll cover RPA here, Representation of People Act. And what else you can put it? Say for example, UPSC does ask questions from areas like Lok Adalat, Legal Services Authority Act, PESA Act, maybe certain other important legislations which is there in the current affairs. So probably we'll touch upon all those things here. There is a possibility where UPSC may ask one question from these areas: Lok Adalat, Legal Services Act, PESA Act, official languages. Okay, so these will be covered at the miscellaneous topics. So how many themes overall that we are going to cover? So this is the order in which we are going to do the entire polity. Okay. So what would be our approach? Say for example, if I take executives, I will cover everything under the executives. We will also do practice questions. We will also do previous year questions, at least 15 years of previous year questions from the executives. So first we will have the conceptual clarity, then we will do the questions. So in that way, every topic by topic we are going to proceed. And wherever there is a relevant current affairs, I will try to touch upon those relevant current affairs also. This is going to be our modus operandi. This is going to be the way that we are going to proceed every topic. So what is expected from you? So the expectation from your side is, it is not mandatory that you come prepared. So, but if you want to be proactive, you can, now you know the order that in which I am going to cover. So probably today I will try to cover almost the entire executive. So maybe when you come for tomorrow's class, if you want, you can cover say the parliament chapter. But again, I wouldn't say it is mandatory. But what is mandatory is whatever we cover in the class that you go and revise. That is mandatory. Unless until you do that, uh, you might miss out on certain things. Yes, you can observe a lot of things in the class, but to have the full benefit, I will suggest you to go and revise it. And wherever you have any issues, you can approach me with regard to those doubts and all those things. All right. So this is how we are going to proceed. So before I proceed, if you have any questions, probably you can ask me your questions, and then I'll proceed with the first topic, that is the executives. So executives is one area where you can expect 1 to 2 questions. So definitely one question, maybe it may go to 2 questions also, sometimes 3 questions also. But however, you'll have to understand, not necessarily from all the themes questions might come every year. There are certain themes where the question may not come. But overall, out of all these themes, you can expect around 14 to 15 questions. That is what on an average that I can tell you. All right. Any questions from your side? Any queries from the online students or the offline students? I'll just take up those questions, then I'll just proceed further. Anything that you wanted to ask? Okay, so if you have any questions, you can ask me. In the meantime, I just want to go through the practice questions. I have given some 10-15 practice questions. Just take a few minutes, just go through those practice questions. Why I am telling you to go through the practice question is, so as and when I discuss, you will be able to correlate with most of the things. Just go through it once. So don't look for the answers. If you know the answers, it's okay. Otherwise, just go through the questions. Online students, you can ask your doubts online. You can just put it in the comment. I'll try to attend your questions as well. Okay, don't do the previous year question, just do the practice question. Previous year questions will do it later. PPT, PPT, नहीं इसका PPT, किसको भेज दो, पूछ लेना, PPT भी मैं, इसको PPT चाहिए, ये word file, I want the PPT. Don't try to apply your mind too much, just go through the questions very quickly. If you are comfortable, it's okay. If you are not knowing the answer, it is all right. That's why we are here, to solve all these questions. All right, have you gone through it? Is that done? 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 All right, okay, please listen. So try to make sure that most of the key points are given in the handout itself, but maybe few extra things you have to note it down. So try to note down in the handout itself. So whatever in addition to, so probably some points that you have to remember in your own way that you can understand, whatever way you can understand and recollect, in that way you will have to make a note, so that it becomes easy and effective for you to revise before the examination. One of the biggest problem to be successful in UPSC examination is whether you have the material to revise them before the examination. So once you have a proper material to revise them before the examination, it becomes extremely easy for all of you. So try to make sure that you make a note, try to consolidate. So in this way you will hit around 15 to 20 handouts. So whatever handouts that you get, you try to consolidate all those things. So it becomes easier for you to revise before the examination. All right. All right. So the first thing that I want to do is, as I already said, in the executives, we are going to take up the topic of what is called as the president. So we'll see as it is there in the constitution. My approach is, it is not from the books, but it is from the constitution of India. So I already told the students, you can follow the Lakshmikant, no doubt that it is a very good book. But think from the examination point of view, no question setter is going to refer Lakshmikant for taking the questions. They will pick the questions from where? They are going to pick the questions from the constitution of India. So most of the way that I have organized is from what is called as the Indian constitution. So why I am trying to brief this in the very beginning stage itself, sometimes you might feel, okay, there are certain topics in the president is missing in whenever I cover about the president, but don't worry about it. I will come back and I will do it in the other part. Say for example, certain things I might cover in the legislature also. But overall, whatever is there in your Lakshmikant book, whatever is there in the entire constitution, and all these things will be covered. Okay, so try to observe whatever is happening in the class. So gradually, we'll do all the things. So the first topic that I want to do is the President of India. So try to be interactive. In case if you have any questions, you are welcome to ask the questions. But please do not interrupt me in the middle. So when I am discussing something, so have the patience to listen to that. Try to observe as much as possible. So whenever your time comes, you can ask me the questions, I will take up your doubts and I will try to answer them as far as my knowledge is concerned. Alright, so the first topic that I wanted to do is the President of India. So if you look into the constitution says that there shall be a president. So is it important for you to remember all the articles? No, do not remember all the articles, but try to remember the provisions in the constitution. UPSC is not going to focus upon the articles. There is a separate class I will do for certain important articles where there is a possibility UPSC can ask you questions, but otherwise it is not important, but otherwise try to remember to the provisions. So if you look into the constitution says that there shall be a president. So definitely there should be a president, and as per the constitution of India, the president should always be there, and who is also the head of the union executive, which you all know. Okay, if I ask the question that yes, the constitution requires a president and who is also the head of the union executive, is that president of India, is he a real executive or a nominal executive? Most of you might know an answer for that. The president of India is what? The president of India is only a nominal executive and he is not a real executive, which we will try to subsequently understand what is his constitutional provisions, but as of now try to understand that there shall always be a president, and without the president the country cannot function. The president should always be there, but he is supposed to act as what? He is supposed to act as a nominal executive, because India as a constituent assembly, when they are deciding as to what is the kind of government that we will have, they have chosen for what is called as a parliamentary democracy. In most of the parliamentary democracy, the president would be what? A nominal executive. Okay, so in India also the president is merely a nominal executive. But if the question comes, is the president the head of the union executive, the answer is right or wrong. As per the constitution of India, suppose let us assume the statement is saying, as per the constitution of India, the president is the head of the union executive. Is it true or false? That is definitely true. That is what the constitution says, but he is a nominal executive. For someone to get elected as a president, that means the president shall always be there, and as per the constitution of India, the president shall also be elected, because the constitution of India is a republic constitution. That means the head of the state shall always be elected, be it indirect or direct when you talk of republic, but the head of the state has to be elected. So the constitution also talks about as to how the president shall be elected, and for which the constitution also provides for certain qualifications. So anybody who is having only these qualifications, only they can be elected as the president of India. Or in other words, anyone who is having this particular qualification, only they can contest the election, because as I already said, the president has to be elected. So what are the qualifications that is given in the constitution? First and foremost qualification is he should be a citizen of India. Okay, if I ask a question, when I say that the president should be a citizen of India, he should be a natural born citizen or a naturalized citizen. They can be either, or it is something that they should be a natural born citizen. In case of India, it does not matter whether he is a natural born citizen or a naturalized citizen. In fact, there is no such distinction exists in the Indian constitution. There are certain countries, say for example United States of America, they have a distinction in their constitution as to who is a natural born citizen and who is a naturalized citizen, but in India it does not matter. In India, he should be a citizen at the time of contesting the election. Okay, so first is he should be a citizen of India. He should have completed 35 years of age, and here is a very crucial word that you should note down. He should have completed 35 years of age. For certain other provisions in the constitution, they should have attained 25 years of age, they should have attained 30 years of age. So make sure that there is a difference between the word attained and completed. Say for example, in case of Lok Sabha elections and Rajya Sabha elections, the term that is used in the constitution is they should have attained, or they should not be less than 25 years of age. But whereas here he should have completed 35 years of age. Okay, citizen of India, completed 35 years of age, and apart from that, he should also be qualified for election to Lok Sabha. What does this mean? Can anyone tell me? That means any person who wanted to contest election to the Lok Sabha, sorry, contest election to the President of India, if you want to file the nomination paper to contest the election, he should have these following qualifications: citizen of India, completed 35 years of age. In addition to that, he should also have the qualification to contest election to the Lok Sabha. Now, you please tell me, when I say that he should be qualified for election to the Lok Sabha, there are certain conditions which is given in the constitution as to what are all the qualifications one should possess to contest election to the Lok Sabha. That means somebody who is contesting election to the President of India should also have all these qualifications. Now, what are those qualifications? Those qualifications are given under Article 84 of the Constitution. So, what are those qualifications? There also it is saying that one should be a citizen of India, which is already there, and apart from that it is also saying that one should not be less than 25 years of age, but that is overruled because he should have completed 35 years of age. So, these two things are covered, and apart from that it is also saying he should subscribe to an oath in front of an authorized authority. That means anybody who is contesting election to the Lok Sabha, they should subscribe to an oath in front of an authorized authority. So, who is this authorized authority in case of Lok Sabha elections, or who will appoint this authorized authority? Somebody who is contesting election to the Lok Sabha. So, in case of president also, he should subscribe in front of an authorized authority. And who will determine this authorized authority? I know in both the cases anyways. Who will determine the authorized authority? Does anyone know? It is the Election Commission of India in both the cases. So, try to understand, anybody who is to contest election to the Lok Sabha should subscribe in front of an authorized authority. So, anybody who is to contest election to the President of India should also subscribe in front of an authorized authority. Now, try to have an understanding, in both the cases who is to conduct the elections for the Lok Sabha as well as for the election of the President. It is the Election Commission of India whose constitutional responsibility to carry out the elections. So, who will appoint the authorized authority in both the cases? It is the Election Commission of India. So, that means you should have an understanding, anybody who wanted to contest election to the President of India, they should subscribe to an oath in front of an authorized authority, and that authorized authority will be appointed by the Election Commission of India. So, it is the Election Commission of India that is going to appoint the authorized authority. Try to remember all these things, alright. So, the Election Commission of India will appoint the authorized authority, but does anyone know who is this authorized authority? In case of the President, someone who wanted to contest election has to subscribe to an oath in front of an authorized authority. That authorized authority is to be appointed by the Election Commission of India. But who is this authorized authority? Is there any law, is there anything which is mentioned in the constitution as to who will be this authorized authority? Does returning officer, but who is designated as the returning officer? Who is designated as the returning officer? But even before that, my question is it mentioned in the constitution as to who is to be appointed as the returning officer? It is not mentioned in the constitution. It is only through the conventional practice that the Election Commission of India appoints either the Secretary General Lok Sabha or the Secretary General Rajya Sabha as the returning officer. Very, very important. So, who is usually appointed as the authorized authority is appointed by the Election Commission, but who is usually the authorized authority? It is either the Secretary General. Does anyone know who is the Secretary General Lok Sabha or Rajya Sabha? Who is usually appointed as a Secretary General Lok Sabha or Rajya Sabha? It is usually a senior most IAS officer. So, they have a similar rank as that of Secretary to the Government of India. So, whoever is appointed as a Secretary to the Government of India, similarly an IAS officer is either appointed as the Secretary General Lok Sabha or Rajya Sabha. They are the highest administrative officers for the Lok Sabha and Rajya Sabha. So, for example, if one election, if the Lok Sabha Secretary General is appointed as the returning officer, in the next election it will be the Rajya Sabha Secretary General. So, alternatively they will be appointed as the returning officer. Now, why this conventional practice? The conventional practice is something that you have to understand as to who is part of the electoral college of the President of India, who is part of which I will subsequently discuss, but you may have a basic idea that there is something which is called as electoral college. Who is predominantly part of the electoral college of the President? It is the elected members of the parliament and of course, the members of the state legislature also there. So, the idea is someone who is aware of the parliamentary protocols should be appointed as the returning officer. So, that is the reason the conventional practice is it is usually the Secretary General Lok Sabha or the Secretary General Rajya Sabha is alternatively appointed as the returning officer. But who will appoint them? The Election Commission of India. Is that clear to all of you? That means anybody who is contesting election to the President of office of the President, they should subscribe to an oath in front of whom? Either the Secretary General Lok Sabha or the Rajya Sabha, whoever is appointed as the returning officer by the Election Commission of India. So, now see the qualification. Should be a citizen of India, completed 35 years of age, and then they have to subscribe to an oath. But is this condition sufficient enough? No. In addition to that, for someone wanted to contest election to the Lok Sabha, there is another condition also, that they should also satisfy other qualifications as may be determined by the law of the land. So, that means in addition to this, if at all there is any other qualification for someone to fulfill to contest election to Lok Sabha, all those qualifications shall also be fulfilled by whom? For someone contesting election to the office of the president. So, is there any other qualification that needs to be fulfilled for someone who wanted to contest election to the Lok Sabha apart from all those things? There are two important things that they have to fulfill. First important qualification is that they should be a registered voter from any constituency in India, or in other words, that anybody who wanted to contest election to the Lok Sabha, they themselves should be a registered elector. To put it in a very simple way, what do you understand by this? That means, suppose if I wanted to contest election to the Lok Sabha, in addition to all these qualifications, what should I fulfill? That I should have a voter ID. Unless and until I have a voter ID, that I am registered as an elector from any constituency in India, I may not be able to contest election to the Lok Sabha. That means, for someone to contest election to the office of the president, he should also be registered voter from any constituency in India. So, does anyone know how many parliamentary constituencies are there in India? 5? How many parliamentary constituencies? That means I am asking about how many Lok Sabha constituencies are there. How many constituencies? Anybody who is confident enough? 5? 545? How many of you think it is 545? How many of you think it is 543? How many of you think it is 550? Anybody who thinks it is 552? These are the four options: 545, 543, 550, 552. My question is, how many parliamentary constituencies are there? Yes? Anybody else who is also of the opinion 543? Very good, it is 543. So, 545 is not the number of constituencies. Okay. So, the number of constituencies is only 543. 545 used to be there because two nominated Anglo-Indian members were there. That also has been done away with right now, which we will subsequently discuss. So, how many constituencies are there? 543. That means anybody who want to contest election to the office of the president should be an elector from any of these 543 constituencies. Okay, it can be anywhere in India. Okay, that should also be fulfilled. Okay, so that is another condition. Is there any other condition as per the law? So, here to put it very exactly, precisely, the law that I am talking about here is a Representation of People Act. It is a Representation of People Act which mandates these conditions for someone who is contesting election to the Lok Sabha. So, the same condition will also apply to the President of India, whoever is contesting election to the office of the President. Is there any other qualification that is required? Very good. They should not be disqualified under the Representation of People Act. That means they should not be convicted in a court of law, or there shall not be any other disqualification. They should not be disqualified under the Representation of People Act. There are number of ways by which they can be disqualified under the Representation of People Act, which is not I am discussing right now. But make sure one understanding you should have is, as per the Representation of People Act, basically two things they have to satisfy. One is that they should be an elector from any constituency in India. They should not be disqualified as per the Representation of People Act. There are a number of ways they can be disqualified. Say one can be criminal conviction, one can be engaging in corrupt practices or electoral offences. That is not what I am going into. I will discuss that when I take up the Representation of People Act. But basically, they should not be disqualified under the Representation of People Act. So, if he satisfies all these conditions, then also he is not completely eligible. Then also he need to satisfy certain other conditions. So, what are the things that you have seen so far to contest election to the office of the president? First is he should be a citizen of India. He should have completed how many years? 35 years of age. He should subscribe to an oath in front of an authorized authority. Who is authorized authority? Who is the authorized authority? It is the Election Commission of India. The Election Commission of India will appoint the authorized authority. And who is usually the authorized authority? Secretary General Lok Sabha or Rajya Sabha. Is that mentioned in the constitution? It is only a conventional practice. Okay. So, then once it is appointed, he subscribed to an oath. And then in addition to that, he shall also satisfy the other conditions under the law, that is the Representation of People Act. That means here he should be an elector from any constituency in India, and he is not disqualified under the Representation of People Act to contest election to Lok Sabha. And apart from that, he should also not hold on to any office of profit. That is another condition he should satisfy. Now, only when he satisfies all these conditions, including the office of profit, then he is eligible to contest election to the office of the president. So, when I say that he should not hold on to any office of profit, my basic question is the term office of profit defined in the constitution? In fact, in number of places the word office of profit is used, not only with regard to the president. It is especially used with regard to the legislature, which I will subsequently discuss. But wherever it is used, the term is the same, the definition will remain the same. So, my question is the term office of profit anywhere defined in the constitution? It is nowhere defined in the constitution. That is the basic understanding you should have. The term office of profit is nowhere defined in the constitution. So, how do we understand as to what is an office of profit? Is only through the judgment that is given by the Supreme Court. The Supreme Court has given a lot of judgments. So, one important judgment that I would say is, you do not have to remember the cases as of now for the prelims, but try to know as to what is this office of profit, and you should know that the office of profit is nowhere defined in the constitution. What is office of profit? Office of profit is any office which is either under the central government, state government, or under the local bodies. That means office of profit is basically a body which is executive in nature. It is either an office either under the center, state, or local authorities, by virtue of which some profit is receivable. That is what is considered to be an office of profit. So, the key word that I am using, every single word is very, very important. So, what is an office of profit? It is an office either under the center, state, or a local body, by virtue of which a profit is receivable. It is not necessary somebody is receiving a profit, but even if the profit is receivable, then itself it will come under the definition of what is called as an office of profit. So, my question is, what do you understand when I say the profit is receivable and the profit is received? So, I am saying that it is not necessary that they are receiving a profit, but even if the profit is receivable, still it will be considered to be an office of profit. So, these two things, does it make any difference when I say the profit is receivable and the profit is received? So, for example, somebody occupying a government office, but they are saying that I will hold on to this office, but I am not taking the salary, I do not want the salary. So, in that case, they are not taking any profit, which means their salary, their allowances, and other privileges may be considered to be a profit. But suppose let us assume a person X is there, and this X is occupying a government office, but he is saying that I do not want to take this salary. So, will that still be considered to be an office of profit, even if he is not drawing the salary? Because whether you take the salary or you do not take the salary, but whether if it is receivable in the first place, then itself it will be considered to be an office of profit. So, what is the understanding that you should have? Somebody who wanted to contest election to the office of the president, he should satisfy all these conditions. Now, I wanted any one of you to summarize all these conditions. What are the conditions that one should fulfill? Now, qualifications means only when he possesses all these qualifications, he can file the application. So, what are the qualifications? Citizen of India, completed 35 years of age, subscribe to an oath in front of an authorized authority as appointed by the Election Commission of India, and then he should not be disqualified under the Representation of People Act, and he should also be an elector from any constituency in India, and then he should also not hold any office of profit, and this office of profit is not defined in the constitution. So, any office either under the center, state, or local authority by a way of which any profit is receivable, then that would be considered to be office of profit. Now, once you satisfy all these conditions, then you are eligible to apply to contest election to the President of India. Not necessarily you will become the president, you can apply to become the president. Okay, so one more thing that you have to understand is, for this petition to be accepted, so for not the petition, for this application to be accepted, it is also important, suppose if I wanted to contest election to the office of the president, provided I satisfy all these things. Apart from this, there is also a law which is called as the President Vice President Election Act 1952. That mandates certain other conditions. And one important condition is, suppose if I wanted to make an application to contest election to the office of the president, then my application should be accepted, or it should be accepted by 50 proposers, and it should be seconded by 50 seconders. And all these 100 members, 50 as proposers and 50 as seconders, should be from the electoral college. So, among the members of the electoral college, my application for president candidature has to be proposed by how many members? 50 members, and that shall be seconded by another 50 members. But that is again not mentioned in the constitution. That is not a conventional practice also. It is mentioned where? It is mentioned as per the President and Vice President Elections Act. So try to remember all these things. Any of these things may be asked in the examination. All right. So this is the first thing that I should you should first have an understanding with regard to the President. Okay. Now my question is, can a sitting President contest election to the office of the President again? Is it possible under the Constitution? How many of you think it is yes? Please raise your hand. Be very sure. Are you very sure of this? Can a sitting Vice President contest election to the office of the President? Is it possible? But my question is, will it not amount to office of profit? A sitting President contesting election to the office of the President, will it not amount to office of profit? Because one of the basic condition is that they should not hold on to any office of profit. It is an executive post. The office of the President is an executive post, and he is drawing the salary also. But try to understand, there are certain exceptions under the Constitution as to, although it is an office of profit, it is exempted for contesting election to the office of the President. Only 4 such offices are exempted under the Constitution. What are the offices? Office of the President, Office of the Vice President, Office of the Governors of any of the state, or Office of the Ministers either at the center or at the state level. That means anybody occupying any of these 4 offices, I am repeating it again. What are those offices? Office of the President, Office of the Vice President, Office of the Governors, and Office of the Ministers either at the central level or at the state level. That means they can contest election to the office of the President. Those offices would not be considered to be office of profit. Apart from these 4 offices, any other offices would be considered to be an office of profit. Say for example, let me give this example. Say a secretary to the government of India, he wanted to contest election to the office of the President. He is satisfying all these things, but he is still the secretary to the government of India. Can he contest election to the office of the President? Can he not contest election to the office of the President? Is it possible for him to contest election to the office of the President? Although he is satisfying all these conditions, but he is still the secretary to the government of India. He can contest, but he has to resign from that office. By sitting in that office, he cannot contest election to the office of the President, because that would be considered to be office of profit. But otherwise, under the Constitution, which offices are exempted? Only these 4 offices. Is that clear to all of you now? Okay, this is very, very important. Now, okay, let me put another question. Can a member of parliament or a member of state legislature, a sitting member of parliament or a sitting member of state legislature, can they contest election to the office of the President, assuming that they are satisfying all the other conditions that you have seen? Yes or no? Okay, so just think about it for a moment. Can a sitting member of parliament or a sitting member of state legislature, can they contest election to the office of the President without resigning as a member of parliament? Yes or no? How many of you think yes? Please raise your hand. How many of you think? What did the first question it ask? How many of you think yes? Okay, how many of you think no? Please raise your hand. Okay, so the majority views that no, they cannot contest the election. So can you give me the reason as to why they cannot contest the election? Anybody who is saying no, no, they cannot contest the election. Yes, what is your opinion? Anybody? Somebody who has said no. No, my question is, whatever you say has to be there in the Constitution. Now, you cannot bring out your own logics and say that this should not happen. My question is it there in the Constitution? Does the Constitution prohibit? So most of you are saying no. So what is the reason as to why you said no? President cannot be a member of parliament, but he is only contesting the election. He has not become the president yet. So your answer is right. There should be a separation of powers. So once you become a president, then it's a different story. My question is whether he contests election. That is what is my question. All right. So you are saying that an MP, very good. So now you are coming to the point. So your point is that it shall be considered to be an office of profit. And because yes, the MP also draws salary. But try to understand, when I was discussing about the office of profit, what is the thing that is falling within the definition of office of profit? Any office which is executive in nature. It is an office either under the center, state or the local authorities. But a member of legislature is not an executive post. So it may not fall under the definition of what is called as an office of profit. So the answer is very short. Can a sitting member of parliament or a member of state legislature, can they contest election to the office of the president without resigning from their post? What is the answer? Yes, they can contest, provided they satisfy all the other conditions. Is that clear to all of you? Do not make any mistakes. Now, once you have this understanding, now we'll go to the next thing in the constitution. Is it clear to all of you till this point of time? I don't want anyone to make any mistakes if a question comes from these areas, which we'll subsequently discuss. The practice questions we'll understand. Is that clear to all of you? The qualifications? Please repeat your question. These exceptions are for the executives. An MP and MLA is not an executive, they are a legislature. So, the exception is only among the executives, they are giving some exceptions, alright. So, now come to the next thing, that is conditions of office of the president. Now, before I proceed further, I want somebody to let me know as to what is the difference between qualifications and conditions. Why these two things are separately given in the constitution? If at all, is there any difference between these things? Can you put it in a very simple way? Yes, you are right. In a very layman term. Very good. Very good. So, to contest election is what is qualification. Condition is someone who has got elected as a president and for him to stay in the office. So, that is what is conditions. While qualifications may apply to all the candidates who wanted to contest the election, whereas condition is only for one person who got elected as a president and for him to stay in the office. He need to satisfy certain conditions as well. Is that clear to all of you? Okay, now the constitution also provides for certain conditions to stay as a president of India. Okay, you got elected as a president, but to continue as a president of India, you need to satisfy certain conditions. That is what the constitution says. So, what is the first condition? He should not be an MP or a member of a state legislature. So, what is your name? I think this is the point that you are trying to say. What is your name? Okay. So, try to listen here. So, what is the condition saying? If you look into the qualifications, the qualification does not defer a member of parliament or a member of state legislature from contesting an election, because that is not an office of profit. But the moment you get elected as a president, a sitting member of parliament or a sitting member of state legislature, the moment you get elected as a president, then you cannot hold on to both office. That means you cannot have an executive post also, you cannot have a legislative post also. So, then you will have to give up which one, or in other words, a member of parliament or the office of the member of state legislature automatically cease to exist. That means automatically it will become vacant once you get elected as the president of India. So, try to have a proper understanding. Can a member of parliament or a member of state legislature, can they contest election to the office of the president? Yes, but the moment they get elected, the legislature post becomes vacant. That is the condition. And then they should not hold on to any office of profit. The same definition here. That means apart from the office of the president, they cannot hold on to any of the other office of profit. So, what is the definition of office of profit? It is basically an executive post either under the center, state or the local authority, by way of which a profit is receivable. Okay, so they should not hold on to any office of profit, and they are entitled for official residence and emoluments as determined by whom? Who shall determine their emoluments? Parliament. So, till the time the parliament decides, it is as per which provisions in the constitution. Today we have a law, but for the first president, let us assume the parliament has to decide. But before the parliament decided, it has to be as per where it is mentioned in the constitution, as per it is in the schedule. Which schedule in the constitution? Very good, it is in the schedule 2 of the constitution. Anyways, I will discuss the schedule at a later stages, but try to have this idea also. But till the time, it is only the parliament makes a law. So, once a parliament makes a law, it will be as per the law made by the parliament. There is also one more thing that you have to remember. The constitution also says that the emoluments and the allowances which is given to the president shall not be diminished during his term of office. Can it be increased during his term of office? There is no restriction on that, but it shall not be diminished during his office. That means it cannot be varied to his disadvantage. It can be increased to his advantage. Alright. So, this is what basically you have to understand. So, this itself you can get n number of questions, but maybe you can expect one question from this particular area. Is that clear to all of you? What is conditions and what is qualifications? And in terms of qualifications also, try to remember each and every point that I have discussed. Okay, I said that the President of India in case of India is elected. So, now let us move forward. Let us try to understand as to how the President of India is elected. That is again very important. So far it is clear to all of you? Alright, so we will just move forward. Now, we know that the Constitution of India states that India is a republic. So, can anyone give me an answer as to what do you understand by republic? And how is it different from the concept of democracy? Because many times I discuss with the students, they often get confused between the concept of democracy and the concept of republic. So, first tell me what is republic, and then tell me how is this the concept of republic is different from the idea of what is called as democracy. Very good. Republic is only talking about how one becomes the head of the state. It has nothing to do with the government. It has nothing to do with how the government is constituted. Republic is all giving us an idea that the head of the state is always elected. And do not have a misunderstanding that the head of the state is elected indirectly or directly. Republic does not mean anything. It can be direct or indirect, but it has to, the head of the state is always only through elections. So, while in India, when we say that India is a republic, that means how one becomes the head of the state is always by elections. It can be either direct or indirect. Yes. Now, how is it different from the concept of democracy? Democracy is giving us an idea, it is a political concept which is giving us an idea as to how the government is constituted, and that government is elected by the people. So, while India is both a democracy as well as the republic, the government is constituted democratically through democratic elections, but the president is elected because it is a republic and the president is the head of the state. But however, the constitution allows for what is called as an indirect elections, because again we are a parliamentary democracy and they are going to be the real powers. So, an indirect election has been given to the president, and because the president is to be elected indirectly, the Constituent Assembly has also decided for what is called as an electoral college. So, predominantly who will engage in the election of the president. Now, what do you understand by the word electoral college? Can anyone tell me quickly, what is your understanding of the term electoral college? Electoral college means it is a separate body of people who basically will have the rights to participate in the elections. Apart from those people, the others will not have the right to participate in the elections whenever I use the word electoral college. So, only those people will have the right to vote. So, when it comes to the presidential election, the constitution itself is prescribing an electoral college, and only those people will have the right to participate in the elections. And who are those people as it is given in the constitution? It consists of, again, a very important area, it consists of the elected members of both the houses of the parliament. This is very important. When I say both houses of the parliament, how many houses are there? It is Lok Sabha plus Rajya Sabha. But the key word is, it is only saying elected members of both the houses of the parliament. So, can anyone tell me how many elected members are there in the Lok Sabha? Does the Lok Sabha today have any nominated members apart from the elected members? How many of you think that they have only elected members in the Lok Sabha? How many of you are confident about this? They got only elected members. How many of you think that they have both elected as well as nominated members? Okay. So, try to understand, today the Lok Sabha has got only the elected members. The original constitution, there was provision for both elected as well as nominated members, but that has been now done away with. And do you know which constitutional amendment has done away with? If you remember, very good, 104th Constitutional Amendment Act has not given extension to the Anglo-Indian nomination, which has been now done away with. So, today the Lok Sabha has got only what? The elected members. And how many elected members are there in the Lok Sabha? 543, very good. And Rajya Sabha today As it is in the original constitution, it is a combination of both elected as well as nominated members. So, can anyone tell me today in the Rajya Sabha, the total membership, I am not asking the maximum membership, the total membership, and out of the total membership, how many are elected and how many are nominated? If you have an idea. How many members? The total membership, which anyways we will subsequently discuss all these things when I take up the legislature part, but just because we are discussing, I thought of. So, today the total membership of Rajya Sabha is 245. If you further divide that, it is 233 as the elected members and 12 nominated members. So, the nominated members are not part of the electoral college. The nominated members, but the elected members are part of it. But however, in this case, elected members are also indirectly elected, which we will subsequently discuss, but it does not matter. Only the elected members of both the houses of the parliament are part of the electoral college. So, 543 plus 233, how many members overall who are part of the electoral college in the parliament? 543 plus 233. How much is that? It is 776. It is 776. Okay. So, these are the number of members who are there in the electoral college when it comes to the parliament. But the electoral college is not only about the members of the parliament, but it also comprises of elected members of the legislative assemblies. Now, the key word that you have to note here is, it is saying the elected members of the legislative assemblies. It is not using the word the elected members of the state legislature. Instead of the word state legislature, what has been chosen in the Constituent Assembly, it is the legislative assemblies. Is there any difference between these two words? Instead of using the word state legislature, the Constituent Assembly has chosen the word legislative assemblies. So, what is the difference here? That means it is not inclusive of what is called as the legislative council. Even if the state is having legislative council, the members of the legislative councils are completely excluded. Who are part of the electoral college? Only the members of the legislative assemblies, and even within the members of the legislative assemblies, only the elected members. But however, today you do not have to worry about it, because in the original constitution, in the legislative assemblies also there was a provision for nomination. One person from the Anglo-Indian community can be nominated, but that has also been done away with. So, that means today whoever is part of the legislative assembly in the state, they are all part of it. But however, you still remember the elected members, because in some union territories there are other nominated members also. So, the nominated members will not be part of it. So, who will be part of it? Only the elected members. So, elected members. So, how many state legislature we have got today, or how many legislative assemblies we have got today in our country? Or in other words, how many states do we have in India? That is the question. 28, 29. How many states? 28 states. So, that means the elected members of all the 28 legislative assemblies are part of it. What about the legislative council? If a state is having legislative council, they are completely excluded. It does not matter whether they are elected or they are nominated, they are completely excluded. Apart from that, there are legislative assemblies of certain union territories are also part of it. So, how many union territories today in India have got legislature? How many union territories in India today have got legislature? 3, 2, okay, 3. What are the 3 union territories? National Capital Territory of Delhi, Puducherry, and the recently created Union Territory of Jammu and Kashmir. So, 3 union territories have got legislature. So, all the 3 union territories legislature also part of the electoral college of the president? Yes or no? How many of you think all the the legislatures of all the 3 union territories are part of the electoral college? Please raise your hand. Let us make mistakes or whatever you think, just raise your hand. So, no problem in that. We will try to learn all those things. How many of you think no? It is only the Legislative Assembly of Delhi and Puducherry, and that too elected members. In all the cases, it is elected members. Now, be very clear about it. So, as of now, when you look into the electoral college of the president, it comprises of only 2 union territories. One is the National Capital Territory of Delhi and Puducherry. Because if you see, just listen to me for a moment. Because if you see the original constitution does not provide for the representation of the union territories. It only provided for representation for what? The states. And subsequently the union territories legislative assembly also become part of the electoral college by way of a constitutional amendment, the 70th Constitutional Amendment Act in 1992. When the 70th Constitutional Amendment Act 1992 was made, there were only two union territories which has got the legislature. What were the two union territories? National Capital Territory of Delhi and Puducherry. So these two union territories were specifically included as a part of the electoral college by way of a constitutional amendment. So it is not giving generally saying that union territories which has got the legislature. So these two union territories were inserted and their electoral college were inserted. But then you know that when Jammu and Kashmir became the electoral college only in, when Jammu and Kashmir became a separate union territory only in 2019. So unless and until you make a constitutional amendment and include the legislative assembly of Jammu and Kashmir, they will not be part of the electoral college. So only two union territories and their legislative assembly members and the two elected members of those two legislative assemblies, only they are part of the electoral college. Now that means today, if the next presidential election is to happen, will the members of the legislative assembly of Jammu and Kashmir, will they be part of the electoral college? Will they be part of the electoral college? They will not be part of the electoral college unless and until two ways it can happen. So two ways they can become part of the electoral college. This is just for your own understanding. Okay, so you have to remember they are not part of the electoral college for time being. But two things can be done. Two ways they can also become part of the electoral college. What are the two ways they can become the electoral college? Either a status of state is given to them under Article 3 of the Constitution, automatically they will become part of the electoral college, or making a constitutional amendment and including the union territory of Jammu and Kashmir also. Either of these things has to happen, and if these two things does not happen, they will not be part of the electoral college. That means for time being, are they part of the electoral college? No, they are not part of the electoral college. In fact, this was a big criticism when the state was converted into a union territory, that you are leaving an entire state not to participate in the presidential election. But the government guaranteed it's only a temporary measure, will soon give them the status of a state. Even recently also they have assured in front of the Supreme Court when the elections happen that they will soon restore the status of a state. So once the status of the state is restored, then they will be part of the electoral college, otherwise no. Is that clear to all of you? So you should be very clear as to who is part of the electoral college and who is not part of the electoral college. Now come to the next thing, that is the manner of the election of the president. I would say very important. UPSC is giving a lot of importance to this particular area. Every year they are asking a question. Okay. So let us try to pay some attention in this particular part as to what is the manner of the election of the president. So just listen to my questions carefully. So wherever I put a question, there is a possibility that maybe based on my experience, the students may not have a proper understanding, or there is a possibility UPSC can ask a question. So only those areas I try to ask questions. So don't mind that you may make mistakes. Let us better make mistakes now so that we will not make mistakes in the examination. So try to participate. Okay. So whatever, whether you know or whether you do not know it. Alright. So manner of election of the president. First is it is an indirect election. So whenever I say indirect election, you should have a basic understanding that the people do not directly participate. If the people do not directly participate, then it is an indirect election. And wherever I say it is an indirect election, there is an electoral college in that case. So we already learned the electoral college in case of the president. And then what is the principle of election when it comes to the president of India? If you see the principle of election, it is a system of proportional representation by means of single transferable vote, and the voting is by secret ballot. So three keywords: proportional representation, single transferable vote, and the voting is by secret ballot. Let us quickly have an understanding of all those things. First is secret ballot. What do you understand by secret ballot? You don't have to disclose, and others also will not know to whom the voting has been exercised. Basically, the members of the electoral college, to whomever they are voting, others will not come to know about it. So my question is, in case of the presidential election, is the anti-defection law applicable? Is it possible that the anti-defection law may apply in case of the presidential election? for which you should have an understanding of what is anti-defection law. So you may have that's my understanding, you may have an understanding, but no issues. Anti-defection law I will discuss in detail when I take up the parliament chapter, because it's more related to the parliament chapter. But for someone who may not have a proper understanding, what is this anti-defection law? Anti-defection law is a provision where whenever a party is giving some directions to the members who are part of the legislature, not to all the members. So for example, somebody has contested election from a particular party ticket, and then they have become a member of parliament or a member of state legislature, then they are bound to act in accordance with the direction that is given by the party in the legislature. So when they go contrary to that particular direction, then it means, according to the legal terms, that they have defected from the party, or they are acting against the interest of the party. And if they act against the interest of the party, then they can be disqualified under the anti-defection law. So my question is, suppose let us assume somebody is contesting election to the office of the president. So the party might give some directions, if not formally, they can informally give some directions to all their MPs who are part of the electoral college to vote to a particular candidate in the presidential election. Say for example, suppose the Congress party gives some direction to all the Congress MPs. The BJP party gives some directions to all the BJP MPs. So do they have to vote according to the party directions, or can they vote contrary also? And if they vote contrary, are they liable to be disqualified under the anti-defection law? That is my question. Or in other words, is the anti-defection law applicable in case of the presidential election? It's a secret ballot, so it's very simple. It's a secret ballot. Nobody will be able to come to know. They can give the directions informally, but the anti-defection law cannot apply because the system of election is what? It's a secret ballot system. In fact, in the recent presidential election, it was found that there are a lot of Congress candidates are voted to the BJP candidate. A lot of Congress MPs are voted to the BJP presidential candidate. That because you know that how many vote difference by which they win the elections. But however, they are not liable to be disqualified because it is based on what is called a secret ballot. So secret ballot means the voting will not be disclosed to anyone. The same is the case with regard to, say, let us assume the Lok Sabha election. The Lok Sabha election, is it a secret ballot or an open ballot? How many of you have ever voted in the Lok Sabha elections or the Legislative Assembly elections? So what is your experience? When you go to the polling booth, have you voted in secrecy or in front of everyone you have done the voting? Secret, and you don't have to reveal it to anyone. So that's a secret ballot. So similarly here also it is what is called a secret ballot. So the anti-defection law does not apply. Be very clear about it. That is basically what is called as the secret ballot. Now coming to the concept of proportional representation. So the proportional representation, there may not be any question from this area, but just try to have a brief understanding about it. So when I talk of proportional representation, the Constituent Assembly was thinking, for electing the President of India, the entire country has to participate. Because sometimes the students ask me a question, when there is a real executive, that is a Prime Minister in a democracy, or the Prime Minister who is heading the Council of Ministers, why do we need the President in the first place? Because he is anyways a nominal executive. But what was the necessity to have the President in case of India, when we anyways have the real executives, that is the Prime Minister and the Council of Ministers? So does anyone have an answer? What was the need for the president? Why do you think the Constituent Assembly still wanted a president, though he is a nominal executive? Very good. Say for example, if you talk of the Prime Minister and the Council of Ministers, they are mostly elected on party lines. But we wanted someone as a head of the state who is above all these party politics. And that is the reason, if you see, that they wanted the electoral college of the president, the entire country should participate. And that is why there is also representation from the legislative assemblies of the state. But however, the Constituent Assembly has made it very clear that whenever the states also participate, they wanted to have proportional representation to the states. That means, depending upon the population of that particular state, they should have a say in electing the President of India. Or in other words, every state should not have the equal say, but rather they should have certain powers or certain say in electing someone as a president depending upon the population of that particular state. And that's basically the idea of what is called as proportional representation. or in other words, the members who are there in the part of the electoral college, the value for their votes are not going to be the same. Their value for their votes is going to vary from state to state, and based on which it is going to vary, it is going to vary based on the population of that particular state. So, any state which is having more population, their votes value can be more. Any state which is having less population, their value can be less. So, this is basically the idea of what is called as proportional representation. So, the value of the vote is going to be in proportion to what? It is in proportion to the population. That is a basic understanding. And if you see this proportionate representation, in this way they thought that there could be proportionate representation between states, that is interstates. But they also wanted to have proportionate, say, between center as one agency and the states as one agency. So, that is also possible because there are different values to the votes of the MPs and different values to the vote of the MLAs. So, this is basically what you will have to understand by the concept of proportionate representation. There are few more things that I have to still discuss, and then there is something which is called a single transfer of load, which is merely a procedural thing. I do not want to get into this right now, but try to understand because it is not of much relevance for the prelims. It is a procedural process, how the voting happens, and if nobody is having an electoral quota, how the vote will be counted or how the vote will be transferred from one candidate to another candidate. That is why they have kept the single transfer voting system, but try to have an understanding of proportional representation, secret ballot, and in case of secret ballot, because it is a secret ballot, the anti-defection law is not going to apply. So, is that clear to all of you till this point of time? This is the basic understanding you should have. Now, one basic thing that I said, in case of proportional representation, the value of vote of MLAs is going to vary. It is not going to be the same. Now, there are few key observations that you have to take away, and this is where UPSC is especially asking questions from these areas. Many times it has been asked in the last 10 years, at least 4 or 5 times they have asked, especially from this particular area. Just listen to this right now. So, the Constituent Assembly has given some formulas as to how to calculate the value of vote of a MLA. So, how to calculate the value of vote of an MLA from any state? It depends upon two factors. One is population of that particular state. So, how do you calculate the value of vote of an MLA? Value of vote of an MLA is equal to population of that particular state divided by the number of elected MLAs in that particular state. Okay, so let me just write it very quickly, which is anyways there, but you can just make a note of it. So, how do you calculate the value of vote of an MLA? So, the value of vote of an MLA is population of that particular state, any state for that particular matter. Population of the state divided by what? Elected MLA in that particular state. Elected MLA of that particular state into multiplied by 1 by 1000. Say for example, anybody from the state of Uttar Pradesh, which is having the highest number of MLAs in India. So, does anyone know how many MLAs in the state of Uttar Pradesh? I am taking the example. So, this is, let us assume, Uttar Pradesh. How many MLAs in Uttar Pradesh? 403. Somebody told 80. 80 is the MPs. So, you are not concerned about the MPs here, we are concerned about the MLAs. Okay. So, right. So, in case of Uttar Pradesh, it is 403. And what is the population of state of Uttar Pradesh? That it is very difficult, we do not know. But the question is, how do you get this information of the population of a particular state? Census. Very good. So, my question is, we get the population of the state from the census. So, the question is, which census data is to be taken into account when you calculate this value of vote? Which census? The latest census, 2001 census, 2011 census, 1951 census, 1971 census. Now, which census is to be taken into account? Because without knowing the census, we cannot calculate the value of vote of a MLA. So, if you see the original constitution is saying that the latest census has to be taken into account. That means, whenever the presidential election is happening, at that point of time, you will have to see what is the latest census. So that later census population has to be taken into account. That is what the original constitution said. But however, that provision was amended today. Initially, it was amended by the 42nd Constitutional Amendment Act in 1976. The 42nd Constitutional Amendment Act 1976 amended this, and then they replaced our latest census with what is called as 1971 census. So instead of the latest census, which census was replaced? 1971 census till the year 2000. So till which year the census is likely to continue? Till the year 2000. So whichever census that will happen after 2001, that census may be used. But till the year 2000, which census is to be used? 1971 census. This was happened by the 42nd Constitutional Amendment Act. So then the year 2001 came. In the year 2001, and then any presidential election happening after 2001, which census shall be taken into account? No, no, no. Any census, any presidential election that will happen after 2000. Then the latest census, probably the 2001 census. But in the year 2001, again the constitution was amended by the 84th Constitutional Amendment Act in 2001. And this 84th Constitutional Amendment Act again fixed the census to be 1971 census till which year? 2026. So that means any census or any election that is likely to happen till the year 2026, which census will be taken into account? 1971 census. So any election that will happen post 2026, and then they will take into account the latest census. But till that point of time, which census is to taken into account? It is only the 1971 census. That means today which census is taken into account for population? 1971 census. You remember 1971 census. That is more than sufficient for your examination. But does anyone know the reason as to why this census was brought in instead of the latest census? You might think that it should be the latest census, but instead of that, why 1971 census? Will the using 1971 census will control the population? Very good. It is because majorly the southern states raise this issue in the parliament, that they are controlling the population on the directions of the union government. But on the other hand, the union government directions are not implemented properly in the northern states. So their concern is that we are implementing and we are controlling the population and we are in a disadvantaged position. So in order to protect the interest of the southern states, a constitutional amendment was made. They said that don't worry, that we will continue with the 1971 census till the year 2000, because by the year 2000 they thought that the population growth will stabilize, but it did not stabilize. So now they have kept a new target of 2026 where they think that the population growth will stabilize. Okay, so this is the idea. So now try to understand. So there's one relation that you have to understand. No two states in India. Just listen here. This is what is. You don't have to remember all those things. Just try to remember this logic. Do you think that any two states in India will have same population? So the value of vote of an MLA depends upon two variables. What are the variables? One is population and other is the number of elected MLAs. And do you think that these two variables can be same for any two states in India? They will not have same population also. They do not have same number of elected MLAs. Even if there are same number of elected MLAs, still population might be different. So what is the understanding that you should have? The value of vote of an MLA is different in different states. No two MLAs of different states will have the same value for their votes. And it is a variable of what? It is a variable of population and the number of elected MLAs. Or in other words, no two states, that means 28 states in India, and the value of vote of MLAs in 28 states are different. But what about the value of vote of an MLA in a particular state? They are all same, but different states different. And any state which is having more population, the value of MLA will be more. And any state which is having less MLA, their value will also be more, and if their population is also more. So try to have this correlation. If you have this correlation itself, you will be able to understand this. So the first understanding you should have, the value of vote of an MLA is different in different states. But the MLA is not only the part of the electoral college, there are also MPs also. So there is a formula to calculate the value of vote of a MP. So what is the value of vote of a MP? The value of vote of an MP is, it is calculated based on this, that is the value of vote of all MLAs. What do you understand by value of vote of all the MLAs? Every MLA has a value. Say for example, for Uttar Pradesh, every MLA will have a value. So, what is the value of vote of an MLA in case of Uttar Pradesh? You do not have to remember that, but value of vote of an MLA in the state of Uttar Pradesh is 208. Every MLA in Uttar Pradesh. So, 208 into 403 will give the value of vote of all the MLAs in Uttar Pradesh. In this way, you add up the value of vote of MLAs from all the 28 states and all the 2 union territories. And then when you sum up all these things, you will have a value here. That divided by elected MPs. So, how many elected MPs? How many elected MPs? 543 plus 233. So, when I say elected MPs, it should also include the elected MPs in case of the Rajya Sabha also. So, that is 776. So, this divided by this will give the value of vote of a MP, that is roughly equal to 708. You do not have to remember this also. So, roughly it is 708. So, what is the value of vote of a MP? Is calculated by this particular formula. So, now you tell me whose value will be higher? Is it a value of vote of a MP from Lok Sabha or a value of vote of a MP from Lok Sabha? Is it the value of vote of a MP in Lok Sabha or the Rajya Sabha, which is higher? It is the same. The formula is the value of vote of a MP. So, the value of vote of every MP is the same. The value of vote of MLA from different state is different. The value of vote of an MLA of a particular state is same. Okay, so these are all few inferences that you should know. Once you know these inferences, you will be able to answer any of these questions. So, first inference is the value of vote of an MLA from different state is different. The value of vote of an MLA from a same state is same. The value of vote of an MP is always higher than a value of vote of a MLA. This is again a very important inference, because what is the value of vote of an MP? 708. What is the value of vote of an MLA? It can vary from state to state, but which state is having the highest value? In Uttar Pradesh. And what is the value of vote of an MLA from Uttar Pradesh? 208. And where is 708? So, the value of vote of an MP is higher than value of vote of an MLA from any state. And the value of vote of an MP either in case of Lok Sabha or in case of Rajya Sabha, it is the same. So, try to remember all those things. But if you add up the value of vote of MPs from the Lok Sabha, it may be more than the value of MPs from the Rajya Sabha, because the Lok Sabha is having more members. So, cumulatively it is more, but if you take every single MP, it is the same. So, try to remember all these things. Alright. And then probably you will have to remember one more thing is, for someone to be elected as the President of India, that particular candidate should get an electoral quota. Because if you see the election of the Lok Sabha, or if you see the election of the legislative assemblies, these elections are based on the principle of first past the post system. Can anyone tell me what do you understand by first past the post system? That is a principle to identify who is the winner in the election. So, who can tell me what is the first past the post system? What do you mean by the first past the post system? Suppose let us assume 10 candidates are participating in the election. So, let us assume the running race is there, 100-meter running race is there. In the 100-meter running race, basically based on whatever rules that you know, who would be declared to be the winner? Anyone who crosses the post first. It does not matter at what time he crosses it. But who is declared to be the winner? So, anyone who crosses the post first, that means anyone who is faster than the others, then he would be declared to be the winner. That is basically what is called as a first past the post system. Suppose instead of that, let us assume that I am just changing the rule a little bit. Tell me that who can be the winner. Suppose let I say that anybody who crosses the post in 8 seconds, 100-meter race. So, then who will be the winner? There may not be a winner also. Somebody can cross first, but he cannot come within 8 seconds. Or there can be multiple people who cross it within 8 seconds. That is also a possibility. But that is not how the elections are happening. In case of the Lok Sabha and the state assemblies, it is based on what is called as first past the post system. When I say first past the post system, the only thing the winner has to fulfill is that the winner has to get more number of votes than the other candidates. But how much that vote is not does not it does not matter. He has to make sure he is getting more number of votes. But the presidential election is not based on the principle of what is called as the first past the post system. For someone to be declared to be the winner as elected as the president of India, it is not only necessary for him to get more number of votes than the other candidates. Say for example, let us assume that there are 4 candidates A, B, C and D contest in the election. A is getting, let us assume, 40% votes, B is getting 30% votes, C is getting 20% votes, D is getting 10% votes. So, suppose if it is a first past the post system, who would be declared to be the winner? A would be declared to be the winner, but the election of the president is not based on the first past the post system, but it is based on the principle of what is called as an electoral quota. They need to get certain number of votes. Unless and until somebody gets a certain number of votes, nobody would be declared to be the winner. In fact, suppose if this is the case, then who would be declared to be the winner of the election for the president? In case of the presidential election, who would be declared to be the winner? Because it is not based on the first past the post system. Will there be a winner in this election? No. So, but we always need to have a president. We need to have a president. Without the president, the country cannot function. And the Election Commission of India is conducting the election, and nobody is getting the absolute quota. That is what is electoral quota. I will tell you what is electoral quota. Suppose if this is the election result, so nobody will be declared to be the president of India. But in this case, Election Commission of India may have to go for a re-election. But even if they go for a re-election, then also there is a possibility nobody is getting an absolute majority or an electoral quota. So, to avoid this, there is a process of what is called a single transferable voting system, and that is a very technical thing as to how the election happens. So, do not worry about it right now. So, but in this way nobody can be declared. So, if this happens, then the least person who is or the least number of vote will be ruled out of the election, and then the single transfer voting system will come into picture. And unless and until somebody gets an electoral quota, nobody will be declared to be the winner. So, does anyone know what is electoral quota? 50%, it shall be more than 50% of the valid votes plus 1, that is what is the electoral quota. Or to put it in a very simple way, more than 50% of the valid votes. So, unless and until somebody gets the 50% of the valid votes, nobody will be declared to be the winner of the election. This is basically the electoral quota. So, just remember what is electoral quota. Just remember the value of votes of MP, MLA and the correlation that you have seen, that is more than sufficient with regard to the election of the president. Is it clear to all of you till this point of time? Now, let us try to do some questions. Now, just take a moment. So, just come to the questions. Any questions from these areas? Just go over a handout. I think we can do few questions, if not all the questions. We will see how many questions we will be able to solve with the knowledge that you have got. Okay. This is the first question. Okay. So, come to the first question. Read the first question. With reference to the election of the President of India, consider the following statement. Statement 1. The value of vote of each MLA varies from state to state. Is that true? Does it vary from state to state? It varies from state to state because the population of every state is different. The elected MLAs of every state is different. But you should also understand, when you solve such question, you should also understand which census is taken into account. 1971 census. So, till which point of time this census is likely to continue? Till the fund census after 2026. So, till that point of time. So, the statement is true. Come to second statement. The value of vote of MPs in the Lok Sabha is more than the value of MPs in the Rajya Sabha. This is true or false? Now this is not all the MPs, they are only asking the value of MPs in Lok Sabha. A particular MP in Lok Sabha, is it more than the value of MPs in the Rajya Sabha? No, it is the same. So the value of vote of an MP in the Lok Sabha, suppose if they wanted to make or include all the MPs, they would have used the word cumulative value of all the MPs in Lok Sabha. That is not the case. The value of vote of MP in the Lok Sabha is more than the value of vote of MP in the Rajya Sabha. Is it true? This is false. Which of the statements given above is are correct? It is one only. Is it clear to all of you? But however, when you solve these questions, you should have all the other information also. How to calculate the value of vote of an MP? What is the census? What is the electoral quota? So in that way, if you keep solving, you will be able to solve any question that may come from this particular topic. Okay, so come to the next question. Consider the following statements as per the Constitution of India. So when you read the question, this word is very, very important, because this question is in reference to what? Constitution of India, but students sometimes fail to take note of that, and without taking note of that, you will just see whether this is right or wrong, but it has to be in reference to what? It has to be in reference to the Constitution of India. So consider the following statements as per the Constitution of India. You will have to see whether these things are right or wrong. The notification to the election of the new president must be issued by the Election Commission of India anytime 60 days prior to the expiry of the term of the outgoing president. Now sometimes we will do a reverse learning also, because not everything can be covered when you discuss it. Some kind of reverse learning also we will do. So does anyone have a knowledge about this as per the Constitution of India? Just guess it. Sometimes, see, when you do the examination, my experience also, I have given multiple attempts, cleared prelims in multiple attempts, all the attempts in fact. Now it is not that you will be very sure that you are doing all the questions right in the examination. My personal experience, I never had an experience of knowing that 40 to 45 questions are right. I know that this many questions, definitely I know 100%, okay, these questions are right. In that also 5 to 10% of questions will go wrong, whatever I think, that I am completely sure. But still you will have to go up to 80-85 questions. So that doesn't mean that it is a randomly I am doing it. I will take an educated guess, calculated guess. So somewhere or the other you should also develop that particular thing, but it should be a very educated guess. It should not be a random attempt. You should control your nerves. You should know whether I should attempt or not attempt, and that you will get only when you do a lot of UPSC questions. You get to understand the UPSC language. You try to think in similar lines. Anyways, now just think about it, and what is the option and what is the way that you would go about. The problem with polity is, so don't change your strategy right now. So don't do that. The problem is most of you are reading the Lakshmikant book, so you do not know the exact text in the Constitution. So and most of the students I will what I've interacted, they think that whatever is in the Lakshmikant is there in the Constitution. No. So but if you have read the Constitution of India, you can easily solve it. But having said that, I don't want you to do that right now. So now you do not change your strategy, but just tell me, the notification to the election of the new president must be issued by the Election Commission of India anytime 60 days prior to the expiry of the term of the outgoing president. There is one thing that is given in the Constitution, that the election of the new president should be completed even before the expiry of the term of the incumbent president. That is the only thing that is given in the Constitution, but the Constitution has not given any time limit. So where it is mentioned in the President Vice President Election Act, but not in the Constitution of India. So while the statement is true, but this is not mentioned in the Constitution. So it is mentioned in the President Vice President Election Act 1952. Alright, so come to the next statement. The nomination paper of candidates for the election to the office of the president to be accepted by the returning officer. Who is the returning officer? The Secretary General Lok Sabha, the Rajya Sabha, appointed by Election Commission of India as per the Constitution, conventional practice. As per the conventional practice, requires it to be subscribed by 50 electors as proposers and 50 electors as seconders. Is it true? Is it true as per the constitution? It is true, but not as per the constitution. This is again mandated only in the election of President Vice President Act 1952. It is not there in the constitution. While you can see that if you do not take note of this particular line which is given here as per the constitution, you will end up a different answer. Well, this is true, but not as per the constitution. So, what would be the answer here? Which of the statements given above are correct? Neither one nor two. Alright, so always see, if in case if as per the constitution is not given, then you can go it as right, but as per the constitution this is wrong. Come to the next question, let us see whether we can solve this question. Okay, consider the following statement. Statement 1. As per the conventional practice, the returning officer of the presidential election is usually a Secretary General, Lok Sabha or Rajya Sabha. Is that true? Yes, that is what we have seen. Okay, so this is true. As per the conventional practice, this is true as appointed by the Election Commission. The anti-defection law applies in case of voting in the presidential election. Does it apply? Now, even otherwise also you can know it. Even the Election Commission of India has answered this particular question multiple times. Otherwise also it is based on what is called as secret ballot. So, the anti-defection law cannot apply. So, this is wrong. As per the presidential election rules, it is mandatory for an elector to give all his preferences at the time of voting. Now, this is something that you should know. The principle of election of the president is based on what? Proportional representation by means of single transferable vote. There is a unique feature of a single transferable vote. How many of you voted in the Lok Sabha elections? Anybody has an experience? Okay, so when you have gone to the polling booth, so will you be able to vote to multiple candidates? It is not possible. Today we have an EVM. Suppose instead of that a physical ballot paper is given to you. When a physical ballot paper is given to you, because the election of the president is still based on the physical ballot paper system, and then all the candidates names will be given. So, suppose instead of EVM, if you have a physical ballot paper in front of you, will you vote to multiple candidates? Can you do it? You can do it, but it will become an invalid vote. So, nobody can stop you from doing that, but the vote will become an invalid vote. So, similarly, now in case of president, a physical ballot paper will be given. Suppose if 4 candidates are there, one of the feature of the single transfer voting system is that the members who are part of the electoral college, they can give what is called as preferences. So, this is how the ballot paper will be there very quickly. Suppose if there are 4 candidates, let us assume. So, here let us assume, in one case let us assume the preferences, here there are candidates A, B, C, D or the 4 candidates. So, I as an elector, I can give preferences. First preference, second preference, third preference, fourth preference. I can give A the first preference, I can be second preference, C third preference, D fourth preference. In this way, I can vote my vote. So, will this vote be considered to be a valid vote? So, what is the question is asking? The question is asking, as per the president election rules, it is mandatory for an elector to give all his preferences at the time of voting. So, how many of you think it is mandatory as per the election rules? So, please understand, it is not mandatory for him to give all the preferences. What is mandatory is that he should definitely give the first preference. If the first preference is not given, then that vote will become an invalid vote. But it is not mandatory for him to give all the preferences. He may give or he may not give, but definitely he should give the first preference. Hmm. Okay, so the interpretation thing is a different thing, but as of now I am telling you what is this question is trying to, you try to understand the fact. because such things are likely to happen in the UPSC also. But right now try to understand, the question is trying to say, suppose if 4 candidates are there or 3 candidates are there, whether is he must to give preferences to all the candidates, that is not required. But he should definitely give the first preference vote, otherwise that vote will become an invalid vote. Okay, that is the answer. Okay, so what is the answer here based on that particular interpretation? So this is wrong. So what is the answer here? So how many of the statements given above are incorrect? And again you should make note of the word how. So they are not asking which of the statements, how many of the statements. So absolutely how many statements? It is one only. How many of the, sorry, they are asking incorrect, sorry, it is two only. Please come to the next question. Consider the following statements regarding the President of India. So statement number 1, the electoral college of the President includes members of both the houses of the, the electoral college of the President includes members of both the houses of parliament, both elected and nominated. Is it true? So the nominated members are not part of it. Okay, so that is definitely wrong. A sitting member of the parliament or a state legislature cannot contest election to the office of the president. Is it true? Statement is false or true? It is false. We already seen that he can contest because that is not an office of profit. But if he gets elected, what will happen? He doesn't have to resign. Automatically the office cease to exist. Okay, it is no longer there. So he cannot contest. Is wrong. The emoluments and allowances of the president are determined by an act of parliament. Is that true? Yes, it is to be determined by an act of parliament. So, but till the time the parliament determines that, it will be according to what? As mentioned in the schedule 2 of the constitution. So, how many of the statements given above are incorrect? Again, 2 only. Okay, I think for the remaining things we will have to see, but I think we can solve this question. Come to this particular question that we are ready to do. So, just come to this particular question. Consider the following. Statement 1, proportional representation, single transferable voting system, open ballot. Which of the above mechanisms are associated with the system of presidential election in India? The open ballot is not associated. What is associated with the presidential election? It is secret ballot. Can you give me an example of open ballot in India? Where the open ballot is used? Is there any elections where we use open ballot? Very good. In Rajya Sabha we use open ballot system, which we will subsequently see. So in Rajya Sabha it is either open ballot or it is a partially open ballot. But what is that system? I will let you discuss when I take up the legislature part. But definitely in case of president it is not the case. So in case of president it is the secret ballot. Alright, just take a moment, just go through whatever you have learned. If you have any doubt you can ask me before we move to the next topic. Just give me a moment, I will just go through the online comments and any questions you can ask me. Somebody who wanted to go outside, you are free to do, no issues, but without making any disturbance you just move out and you can come back, not an issue. Hmm. It is very much mentioned in the constitution. Whatever the exceptions that are given, that is office of the president, vice president, governor and the minister either in case of the center or the state, these 4 exemptions are very much mentioned in the constitution itself. That 50 people have to should propose their name and there are 50 electors who second their name. Proposers are those people who put forward him as a candidate. Say for example, I am contesting the election to the office of the president. My candidature is initially supported by 50 candidates in the electoral college. My candidature, that means I am making an application to contest election to the office of the president, and my candidature, my application is supported by 50 members of the parliament in the electoral college. So only the electors can act as proposers, not the others. So electors means whoever is eligible to vote. So among those people, especially the members of the parliament, so they have to 50 people have to propose my name, and that whoever is proposing shall also be seconded. There is no difference between proposers and seconders. Seconders come second in line after the proposers, and that shall also be seconded by another 50 members in the electoral college. So overall, how many people have to support my candidature from the electoral college? 100 people have to support my name in the electoral college. Unless and until somebody gets his 100 people support their name, they cannot contest the election at all, because you will have to restrict the number of people contesting the election as a president. Otherwise, anybody who is having the qualification, they can file the application. But one of the biggest check is where it has to be supported by 50 members in the electoral college and seconded by another 50 members in the electoral college. But again, that is not in the constitution. Where it is mentioned, it is in the President Election Act 1952. Sir, so students are asking, one question is that, is this material sufficient for prelims? I would say if you studiously follow each and every word that is coming out of my mouth, I can guarantee you 80% of the questions. I cannot guarantee 100% of, but I think that is more than sufficient for you to clear the examination if you do the other areas also well. So it will be a great resource for you to revise at least before the examination. That I can guarantee you, the way that we will cover each and every topic. But having said that, you can do the other areas also. You don't have to restrict it, but it will be a great source for you to revise at the time of the examination. Sir, PMP students should read Lakshmikant along with the notes. I would say if you follow this very studiously, it will be a great source. Most of the things in the Lakshmikant will be covered. Only the peripheral areas I will not do, because there is no limit to the peripheral areas. I would say the 20% there is no limit. You can keep on reading for that. Still the questions may come or may not come, but 80% is what is my focus, to make you and to empower you in that 80% of the questions. So it is up to you. If time permits, you can do the other sources also. But if you are lagging time, I would tell you to strictly restrict to this area. Okay. Okay. So please come to the next topic. If there are no questions, shall we move to the next question? Sorry, next topic. Is it clear to you till this point of time? So especially the election of the president is very, very important, where UPSC is asking a lot of questions. But there are also areas where UPSC asks questions beyond this also. Say for example, that is a very unexpected line. In 1 year, they have asked you questions with regard to what is the value of vote of an MLA from the state of Mizoram, or I think from the state of Arunachal Pradesh, Puducherry, Kerala, Madhya Pradesh. That is something which is very unexpected. But even in that case also, if you have understood the logic, you will be able to still take an educated guess. I am not saying that definitely everybody will be able to do it rightly. 80% possibility is there, you can get it right, which I will do that when I take up the previous year question. I will tell you how to solve that also. But now let us move to the next topic, that is the term of the office of the president. So if you look into the constitution, the constitution makes it very clear what is the term of the office of the president. It is 5 years. 5 years since the day he assumes office. Whenever he assumes the office, what is his term? It is 5 years from the day he assumes the office. And if you look into the constitution says the president is free to resign from the office. At any time he can resign it. And to whom he has to submit his resignation? To the Vice President of India. And same is true for the Vice President also, which we will subsequently discuss. He can submit the resignation to the President. So he can resign at any time. He may also be removed from his post for the violation of the constitution. Can the President of India removed from his office? Yes. The only way that he can be removed is through the process of what is called as impeachment. And the only ground on which he can be impeached is for what is called as violation of the constitution. But is the term violation of the constitution defined? Is it defined in the constitution? Not defined. Then how do we know that the president has violated the constitution if it is not defined? or what can be considered to be violation of the constitution? Yes, judicial interpretation. The judicial interpretation has never happened because none of the president has been impeached till this point of time. So we do not have a precedent, in fact, for the removal of the president. In fact, not even the motion has been introduced against any president in India till this point of time. But the Constituent Assembly should have some idea as to what can be seen as violation of the constitution. In general, can you give me an example of what can be seen as violation of the constitution? That's the only ground on which he can be removed. Yes. Okay, if he holds any office of profit, because one of the conditions to the office of the president is that he should not hold any office of profit. Very good. But the president is not holding any office of profit. Is there any other ground what can be seen as violation of the constitution? Violates a fundamental right is not a violation of the constitution. Very simple. The president is bound to act as a nominal executive. If he is trying to become a real executive, not acting on the aid and advice of the Council of Ministers, then he is violating the constitution. That's the very essence of this constitution. So, number of times where it can be seen whether he is violating the constitution is whether he is acting as per the aid and advice of the Council of Ministers. And if he is not doing that, then he is violating the constitution, for which he can be removed. So, you will understand, although it is not defined, when the president can be removed is only when he violates a constitution. So, there is a quasi judicial process, and who is to be convinced that the president has violated the constitution in the quasi judicial process? Who is authority? Who is authority to remove the president? It is a parliament. So, the quasi judicial process will be carried out by the president, by the parliament, which we will subsequently discuss the procedure for his impeachment. So, in the quasi judicial process, in his removal process, there will be a lot of discussions and debates that will happen, where if the parliament is convinced that he has violated the constitution, the president can be removed from his office, which there is a procedure which I will subsequently discuss as to what is the procedure. So, for time being, what you should remember is that what is the term of the president? 5 years, and that is from the day he assumes the office. He can resign from his office at any time, submitting the resignation to the vice president. He can also be removed from his office for the violation of the constitution. And apart from that, suppose let us assume that the president has completed his 5 years term. So, normally what is the term of the president? 5 years. Suppose if he has completed his 5 years term, is it possible for him to continue in the office even after that? There is only one condition on which he can continue in the office even after the completion of the 5-year term, is that if his successor is not able to assume the office. If the successor is not able to assume the office, there is no time limit up to which he can assume the office. He can assume the office as long as the successor is occupying the office. So, this is provided in the constitution. Okay, this is an area where most of the students may not have an understanding. There are a lot of ways by which there can be vacancy to the office of the president, which I will subsequently discuss. One of the ground on which the vacancy can arise to the office of the president is his term is getting completed. When his term is getting completed or there is an expiry of his term, in this case, who will act as a president of India? How many of you think it is a vice president? Okay, the sitting president is there now. Draupadi Murmu, she is the president of India. Her term is getting expired. Suppose let us assume after a certain number of years. And when her term is getting expired, then who will act as a president? So, try to understand, as per the constitution of India, the new president has to be elected even before the expiry of the term of the incumbent president. That means before the expiry of the previous president term, the new president has to be elected. That is very, very important. All right. But now let us assume that the new president is elected. The new president is elected, but the new president is not able to assume the office. The new president is elected, but the new president is not able to assume the office because the new president has fallen sick. The new president has met with an accident, because the new president will be elected even before the term of the previous president is over. Maybe a month before, the entire process will be over and the president elect will be waiting till the new president term is getting expired. And the day when the term get expired, the new president will assume the office. But in the interim stage, the new president met with an accident. So the new president is not able to assume the office. Then who will continue as the president of India? It is always the incumbent president and not the vice president of India. So don't understand in this particular case, a vice president will act as a president. No, who will continue to be the president of India? If the vacancy arises because of the expiry of the term, the old president would continue to be the president of India till which point of time? Till the time the new president assumes the office. You will have to be very clear about that. All right. And then apart from that, you should also understand whenever somebody assumes office of the president, there is one formality which is very important under the constitution, is that the new president has to be administered oath. And who will administer that oath? It will be administered by the Chief Justice of India. In the absence of Chief Justice of India, it may be administered by the senior most judge of the Supreme Court. And is the President of India eligible for re-election in case of India? He is eligible for re-election. Is there any restriction on the number of terms for the President of India? There is no restriction when it comes to the term with regard to the President of India. But however, a convention is followed in India that no president in India had more than 2 terms. I think only Mr. Rajendra Prasad has got 2 terms, but otherwise no other president had 2 terms also. That is a conventional practice we are following. But otherwise there is no term or number of term is not fixed in the constitution. Okay, now tell me, in case the president is not there, who will act as a president? Vice president. And if the vice president also suddenly dies, the president is dead, who will act as a president? Chief Justice of India. Is that mentioned in the constitution? Convention mentioned in the constitution? All right, I will come to that particular question a little later. Okay, president dies, vice president also unfortunately dies. Who will act as a president? Chief Justice of India. Chief Justice of India also suddenly dies, unfortunately. Let us take a hypothetical case. Who will act as a president? Senior most judge of the Supreme Court. He also dies, unfortunately. Then who will act as a president? So one student was asking me a question: what if the senior most judge also dies? Then who will act as a president? There are 33 senior most judges in the Supreme Court. There nothing other than that. Anyone who is a senior most judge will act as a president in their seniority. Okay, so it is very unlikely that all the judges in the Supreme Court will die on the same day, which is very unlikely. So whoever is a senior most judge, they will act as the president of India. Apart, it is not based on the age. For that particular matter, when you talk of seniority, the age does not matter. Your age may be less than me, but in terms of seniority, if you are the senior, you are the senior most judge. That is a strict principle that applies when I talk of what is called as seniority. Seniority is on the day where they are appointed as a judge in the Supreme Court. So from there, the seniority is taken into account. It has nothing to do with what is called as the age. So the chronological age does not matter. All right. So this is the basic understanding you should have. Okay. Before we take a break, I think there's a need for a break right now. But before we take a break, now the question is it mentioned in the constitution as to who will act as the president in case if the president is not there? The only one thing is given in the constitution. If the president is not there, then the vice president will act as a president. And subject to certain conditions, within 6 months, a new president has to be elected whenever there is a vacancy to the office of the president. Apart from that, nothing is mentioned in the constitution. Do not have this understanding, the other things are mentioned in the constitution. Apart from this, the constitution is giving the power to the parliament to decide during contingencies who shall act as the president. Under Article 71 of the constitution is giving the power to whom? To the parliament to make a law. And according to that, the parliament has enacted a law which is related to who shall act as a president during contingencies. It is as per the law made by the parliament, but it is not directly mentioned in the constitution. So try to have this understanding. So as per the Contingency President Act, in case if the vice president is also not there, who will act as a president? Chief Justice of India. If he is also not there, senior most judge. Whoever is a senior most judge at that point of time would act as the president of India till the time the new president is elected. All right. So with that, we will take up a break. So we will have a break for how much time? we'll take a break for 15 minutes. Okay, so we'll take a break for 15 minutes. Okay, we'll take a break for 20 minutes and then we'll continue. So time is around 11:15. So then we'll meet at around 11:35. Okay, so we'll continue. We'll try to cover as much as possible. Online students, is it audible? Students who are joined the YouTube live, kindly give me confirmation if you can hear. Just continue with what you have been discussing. All right. So, we'll proceed with whatever you have saying. So, you have seen that the President of India can be removed from his office. So, what is the ground on which he can be removed? The only ground on which he can be removed is for violation of the Constitution. I think it is on. Not audible. Hello, is it audible now? No? Hello. Hello, is it okay now? Is it audible now? Okay. All right. So, the only ground on which the President can be removed from his office is violation of the Constitution. But you have seen that what is this violation of the Constitution is not mentioned in the Constitution. So, who is supposed to verify whether the President has violated? It is to be verified through a quasi-judicial process. And who is authority to carry out this quasi-judicial process is the Parliament. So, we will understand that when the President is removed, a quasi-judicial process where an inquiry will happen in the Parliament. And if the Parliament is convinced that the President has violated the Constitution, then the President stands impeached. But there is a specific procedure that is laid down in the Constitution as to what is the process or the procedure that the Parliament has to follow. So, we are trying to understand that, and in fact, this procedure is laid down in Article 61 of the Constitution. The article is not important, but you should know the process, the procedure as to how the President can be impeached. And what the Constitution says, that if at all the President is to be impeached, the first thing that has to happen is the President has to be intimated that we are going to introduce such a motion in the Parliament with regard to your removal motion. And as per the Constitution of India, this intimation has to be given at least before 14 days prior to the introduction of this particular motion in the Parliament. So, who can introduce this particular motion in the Parliament? It can be introduced by any member of Parliament, and whoever is having an intention to introduce this, they have to notify the President how many days prior? 14 days prior notice has to be given. Okay, 14 days prior notice is given, then the motion is to be introduced in the Parliament. Can it be introduced in either houses of the Parliament? Yes, it can be moved in either houses of the Parliament. This is very important because that is not the case with regard to the Vice President. But in case of President, it can be introduced in either houses. And before introducing this motion in either houses, not only 14 days notice has to be given to the President, but it is also important that this notice, this motion which is to be introduced in the Parliament has to be supported by minimum 1/4 of the members of that particular house. So, unless and until it is endorsed, it is supported by minimum 1/4 of the members of that particular house, then the motion may not be introduced in that particular house. This is I am talking about the introduction itself. Suppose if it is to be introduced in the Lok Sabha, how many members have to support its introduction? 1/4 of 543. Suppose if it is in the Rajya Sabha, it is 1/4 of 245. They have to support this, then only they can be introduced. So, even before all those things, 14 days notice has to be given. 14 days notice is given, 1/4 member supported, then the motion may be introduced. Now, once a motion is introduced, whichever house it is introduced, in that particular house, it is subject to a lot of debate, discussion, and they will discuss whether the President has violated the Constitution or not. And ultimately, that particular proposal will be put to vote in that particular house. and in that particular house it has to be passed with a majority of not less than 2/3 of the total membership of the house. This is a type of special majority. And what is the special majority that is required here? 2/3 of the total membership of the house. So, what do you understand by 2/3 of the total membership of the house? 2 by 3 into 543. Right now it is only 543 in case of Lok Sabha. So, you need to get that majority to get it passed in the Lok Sabha. Okay, it is passed with 2/3 of the total membership of the house in the Lok Sabha. Then the motion will be introduced in the next house. I said that it can be introduced in either house. Assuming that it is introduced in the Lok Sabha, what would be the second house? It would be Rajya Sabha. Suppose if it is introduced in the Rajya Sabha, what would be the second house? Lok Sabha. Now, once the motion is introduced in the second house, in the second house, the president will have the right to defend himself. So, because he will have to follow the principle of natural justice. Now, one of the important aspects of the principle of natural justice is both the parties should be given an opportunity. So, in this case, who is the party who is affected because of this motion? The president. The other party is the parliament, of course, who feels that the president has violated the constitution. So, the president should also be given an opportunity to represent from his side. He may argue that he has not violated the constitution. Now, once this particular option, once particular opportunity is given to the president, and then the motion will be put to vote. Irrespective of whatever the president does, who is the decision making authority there? It is a parliament. So, in the second house, after he is given an option to defend himself, then the motion is put to vote. In the second house also, it is passed with a special majority, that is not less than 2/3 of the total membership of the house. Then the president stands impeached. The moment it is passed by the second house, the president has to be removed from the office. He can no longer hold on to his office. Okay, now the question is, why the president is allowed to defend himself in the second house, not in the first house? Why not this option to defend the president is given in the first house itself? Why this option is given in the second house? That is what is the case. If it is not passed in the first house, then what is the need to defend himself? Let the first house pass it, then let him defend him in the second house. Okay, but however, we do not have a president, because even against a single president, this motion has not been introduced in any of the houses. But this is the procedure that is given in the constitution. So, this is a basic understanding we should have. Is that clear to all of you? So, here probably you may have to understand in which house it can be introduced, how many days of notice has to be given, can it be introduced in either houses, in which house he is given an option to defend himself. So, probably you should have an understanding of all these things. Alright, so with that we will move to the next thing. So, that is also a way by which the vacancy can arise to the office of the president. If the president is impeached, what happens to the office of the president? The vacancy arises. So, when the vacancy arises, then who will act as the president of India? The vice president of India for a maximum of 6 months, within which the new president has to be elected. See, the only thing that is given in the constitution is, which we are going to see next, what are the ways by which the vacancy can arise to the office of the president. But the only thing that you have to keep in your mind is, if the vacancy is going to arise because of the expiry of the term of the president, in that particular case, who will act as the president? If the vacancy is going to arise because of the expiry of the term of the president, the new president has to be elected before that. So, such a vacancy cannot arise because the new president will be elected even before that. But if the new president is not able to assume the office, then the outgoing president would continue to be the president of India till the new president assumes the office. In all other cases, who will act as a president? Then whatever you discussed will follow, the vice president. If not the vice president, the chief justice of India. If not the chief justice, the senior most judge of the Supreme Court. But within 6 months, the new president has to be elected in all these cases. Okay, now come to the next part. So, we will just discuss about this vacancy to the office of the president. So, come to the next topic. Okay, so come to the next thing, that is vacancy to the office of the president. So, what are the ways by which the vacancy can arise to the office of the president? So, this is what is given in the constitution. All these ways the vacancy can arise. Can it arise because of the expiry of the term? Yes. It can also arise because of the fact that there can be sudden death of the president. Is it possible that the president may suddenly die? It might be possible. Anybody can die, so the president can also die. Removal to the office of the president. So, can the president be removed from his office? Yes, the removal is through the impeachment process. Can the president resign from his office? He is free to submit his resignation. He can submit it to the vice president. And there is also a ground what is given as otherwise. So, what do you mean by otherwise? Otherwise means excluding these these things which is explicitly mentioned. Is there a possibility that there can be a vacancy to the office of the president otherwise, apart from these 4 grounds? What is the other ground? Can you give me an example? Chronic illness is not a vacancy. So, we will have to understand there is a difference between what is called as vacancy and absence. If the president is chronically ill, he is still the president of India, but he is maybe absent from the office. And as per the constitution, if the president is absent during the time also, the vice president can discharge the duties. If the president is capable enough, he can still discharge the duties. But if he is not able to discharge the duties, he can advise the vice president to discharge the duties. So, I am not talking about absence, I am talking about the vacancy to the office of the president. Vacancy means there is no president. Absence means there is a president, but maybe he is not able to discharge the duties. What is the other way by which the vacancy can arise? Can you just think of any of the other reasons? Kidnap also again you will have to understand. So, if you are talking of kidnap, suppose let us assume, which is very unlikely to happen. Suppose let us assume the president is kidnapped, but he is still the president of India. And it is because he is the president of India, he has been kidnapped. You cannot say because he is kidnapped, he is no longer the president. We will not consider him as the president because he is kidnapped right now. He is still the president of India. So, the vacancy has not arisen. That is what I am trying to say. Is there any other way by which the vacancy can arise? Mentally, even still he is the president of India. Suppose you elected someone as a president, then he becomes mentally ill, but he is still the president of India. So, there is a vacancy has not arisen because of this reason. If he is convicted, he cannot be convicted in the first place because he exercised a presidential immunity under Article 361, which you will have to understand. There can be no criminal charges against the president of India when he is holding the office. So, only after his term is over, the charge can be framed and he can be prosecuted in the court of law. So, as a president, he cannot be convicted. That is not a constitutional possibility. Anyways, even when he is a president, even if the case has already started, there can be no prosecution against him as long as the president. So, all those things can happen, whatever you are talking about can happen only after his term is expiring. So, in the meantime, nothing can happen. But there is one possibility when you talk of otherwise. Can his election be declared to be invalid by the Supreme Court? His elections can be declared to be invalid by the Supreme Court, thereby this office can become vacant. That is a possibility. But that is not coming under any of these grounds. It is not about expiry, it is not that he has died, it is not he is removed. Removal can be done only by whom? Only by the parliament. And then he has not resigned from the office, but who has declared the election to be invalid? The Supreme Court of India. So, Supreme Court of India is the only authority who can declare his election to be invalid. There is no other court in India which can challenge the election of the president. So, in which court the election of the president can be challenged? It is only in the Supreme Court. The Supreme Court has got original and exclusive jurisdiction with regard to the election of the president. What do you understand by original and exclusive jurisdiction? Original means directly, you do not have to go by a way of an appeal, directly you can go to the Supreme Court, and exclusive means only the Supreme Court, there is no other court which can entertain this petition in the first place. So, with regard to the election of the president, which court in India has got original and exclusive jurisdiction? Only the Supreme Court, and the Supreme Court can declare the election of the president to be invalid. So, that is what the constitution says. Now, the question is who can challenge the election of the president? You and me can be challenge election of the president? Yes. So, who can challenge election of the president? Again, there is no information in the constitution. It is there in the Election Vice President Election Act. As per the President Vice President Election Act, any elector or any candidate who has contested the election of the president, only they can challenge. We know that who are all part of the electoral college. So, any elector or anybody who has contested in the presidential election. So, those they are the party who has locus standi. So, anybody who are part of the elector or who has contested the election, they can challenge the election of the president 30 days, within 30 days after the declaration of result by the Election Commission of India. So, within 30 days, they can make a petition to the Supreme Court, and then it can be challenged in the Supreme Court. And if the Supreme Court finds that the election is not valid, then it can be declared to be invalid. But however, try to understand, the constitution does not prescribe any specific grounds on which the elections can be challenged. So, it is for the petitioner to challenge on any of the grounds he is willing to challenge the election of the president. No specific ground is mentioned in the constitution, but the constitution specifically says the ground on which it cannot be challenged. So, only this reverse is laid down in the constitution. So, try to understand, the constitution is not saying the ground on which the election can be challenged, but what the constitution is saying, the ground on which the election of the president cannot be challenged. So, what is the ground on which the election cannot be challenged? Apart from this, on all the other grounds you may challenge, but what is the ground on which it cannot be challenged as per the constitution? Is the election of the president cannot be challenged on the ground that at the time of election the electoral college was not full, or at the time of the election the electoral college was vacant. So, that means you should have an understanding, it is not necessary that always the electoral college is full whenever the election of the president is happening. Even if the electoral college there is a vacancy, still can the election commission go with the conducting the election of the president? Yes, it is still the responsibility of the election commission of India to go and conduct the election, because why? Because the new president has to be elected even before the expiry of the term of the incumbent president. So, you cannot wait for an electoral college to be filled. Now, what are the grounds on which there can be vacancy to the electoral college? There is a possibility that somebody has died, some MP or MLA has died, so by-election has to happen. There is a possibility some of the state has been kept under the president rule, so the legislative assembly is dissolved. All these things does not matter. Whenever the president election is supposed to happen, the Election Commission of India has to conduct the election. Why? Because before the expiry of the incumbent president, the new president has to be elected. So, this is not a ground on which you can challenge it. So, please try to understand, does the constitution provides a ground on which the election is to be challenged? No, but the constitution prescribes the ground on which it cannot be challenged. This is the ground on which it cannot be challenged. Okay, now the election of the president is challenged and you know that once the matter goes to the Supreme Court, the court might take some time. It may take 3 months, 6 months, whatever it is, before it can give a verdict on this particular matter. Suppose election is challenged today and then the Supreme Court comes and gives a judgment after 6 months, but in the interim time he is continuing to be the president of India. But after 6 months, say let us assume the Supreme Court is declaring the election to be invalid. So, what will happen? All those actions which is done by the president in the last 6 months, will they continue to be valid or will they be invalid? How many of you think that they will continue to be valid? They would continue to be valid as per the Constitution of India, because anyways the president is only a nominal executive. He has not done anything on his own. It is based on the aid and advice of the Council. So, for example, in these 6 months, he would have given assent to certain bills, he would have made appointment to certain judges of the Supreme Court or the High Court, he might have appointment of some of the ministers, he might have made some appointment to constitutional positions. Will all these appointments continue to be valid? All these appointments would continue to be valid. Okay, now the Supreme Court has declared the election of the president to be invalid. So, now who will act as the president of India in this case? The vice president. And for how long the vice president can continue to be the president of India? For a maximum of 6 months, but as soon as possible within this 6 months, the new president has to be elected by the Election Commission of India. Is that clear to all of you? So, if you talk of the vacancies can arise for any of these reasons, but in case of death, in case of resignation, in case of removal or otherwise the Supreme Court declaring the election, in all these cases the vice president would act as the president. And for how long he can act as a president? Maximum 6 months. In the meantime, the new president has to be elected. But In case if the vacancy is going to arise because of the expiry of the term, in this case who would act as a president? The outgoing president would continue to be the president till the time the new president assumes the office. In this case, the vice president cannot act as the president. This should be very clear in your mind, alright. And we already seen as to what in case of election dispute, where it can be challenged, who can challenge, and all these things. Alright, so come to the next part. Is that clear to all of you? Okay, so come to the next thing, that is the Vice President of India. So now we will move to the Vice President. There are few more things which I will have to discuss about the President, but I will come back to those areas when it discuss in the Parliament chapter. So don't think something is being left out, don't worry. I have a way of covering all the things, which is most of the things in your lecture will be covered, don't worry. But I have my own way and my own style of covering it, okay. So come to the next thing, that is the next topic, that is the Vice President. So if you look into the constitution also talks about that there shall be a vice president. So similar to that of the president, the vice president should also be there. And in case of India, the vice president shall also be elected. And how he is to be elected? He is also elected through an indirect election. So that is what is given in the constitution. But however, does anyone know what is the function of vice president of India under the constitution? He is the ex officio chairman of Rajya Sabha. So normally what is his duty? To act as an ex officio chairman of Rajya Sabha. So my question is, what do you mean by ex officio chairman? What do you mean by ex officio chairman? In addition to the vice president, he is given an extra charge. He is chairman, therefore he is vice president. He is elected as a vice president only. He does not become a chairman and then he becomes a vice president. He is elected as a vice president. Okay, tell me, as a vice president, what is his duty? What is the duty of vice president under the constitution of India? He has no other duty except being the chairman of Rajya Sabha. So what does it mean by ex officio? Ex officio means by virtue of one's status, he automatically occupies that particular office. He is not appointed to that particular office, or he is not elected to that particular office. So that means, as per the constitution, in general, ex officio means by virtue of one's status or by virtue of one's position. That means by virtue of being the vice president of India, he automatically becomes what? He automatically becomes the chairman of Rajya Sabha, and in fact that is his function. He has no other function unless and until the president is there, and if the president is not there, then he also acts as the president of India. But however, try to understand, if the vice president is acting as the president of India, can he continue to be the chairman of Rajya Sabha? So normally it is a duty of the vice president to act as what? To become the ex officio chairman of Rajya Sabha. But suppose if the president suddenly dies, so therefore the vice president is acting as the president of India. In that case, will he also continue to be the chairman of Rajya Sabha? No, he cannot continue to be the chairman of Rajya Sabha, because try to understand, whatever conditions that you have seen for the president will also apply for someone who is acting as a president. So anyone who is the president shall not hold any office of office. So that means he can also not act as the vice president, or he cannot perform the duties of what is called as the chairman of Rajya Sabha. So under such a circumstances, who will act as a chairman of Rajya Sabha? Who will act as a chairman of Rajya Sabha? Of course, the deputy chairman of Rajya Sabha. There is a deputy chairman elected in that particular house. So he will act as the chairman of Rajya Sabha. But the deputy chairman who is acting as a chairman of Rajya Sabha, will he also be the vice president of India? Yes? No? Will he also be the vice president of India? In that case, then who will be the vice president? The vice president is already there. The vice president is acting as the president, and the deputy chairman will function as the chairman Rajya Sabha. The vice president has no specific function to perform. It is just that he has to act as a chairman, or he is to act as the president of India, in case if the president is not there. So in that particular circumstances, you don't have to elect a new vice president, and that is also true. Even suppose, let us assume the president is there. Let us assume, but what is the duty of the vice president? Who is the ex officio chairman of Rajya Sabha. If the vice president suddenly dies, vice president dies, So, in that case what will happen? The president is there, the vice president suddenly dies, who is ex officio chairman of Rajya Sabha. In that particular case, who will perform the duties of chairman Rajya Sabha? Deputy chairman. So, do we need to elect a vice president immediately? There is no specific role for the vice president. So, the constitution says the vice president has to be elected as soon as possible. There is not even a time limit that is given in the constitution. So, within which time the vice president has to be elected? As soon as possible by the Election Commission of India. So, you can ask me a question in the meantime if the president dies, because the deputy chairman will perform the duties of the chairman. But what if the president dies in the meantime? Because you do not have a vice president, the president dies. Then also we have the contingency plan. What is the contingency plan? The Chief Justice of India, and if he also dies, then we have the senior most judge of the Supreme Court. So, the position of vice president is not very significant. It is only that he acts as the ex officio chairman of Rajya Sabha. Okay, and then the question that I have asked is that if the deputy chairman of Rajya Sabha, when he is performing the duties of chairman Rajya Sabha, will he also be the vice president? No, he is only the deputy chairman of Rajya Sabha. That is not going to work that way. So, vice president has to be elected by an electoral college. Is that clear to all of you? Alright, so now come to the next thing. So, if you look into the vice president, for the vice president also certain qualifications are given. So, for someone to contest election to the office of the vice president, so here also he should be a citizen of India, similar to that of the president. He should have completed 35 years of age. 35 years of age. And then we have seen that he should be qualified to contest election to the Lok Sabha. Instead of that, here it is given, he should be qualified to contest election to the Rajya Sabha. But for the Lok Sabha and the Rajya Sabha, there is no difference, it is the same. But that is overruled by this 35 years. The only difference between Lok Sabha and Rajya Sabha is there should not be less than 25 years of age, here they should not be less than 30 years of age. But both the things are overruled because here what is the age limit? It is 35 years. And then apart from that, he should not hold on to any office of profit, same definition, whatever you see with regard to office of profit. Now, here also they should subscribe to an oath in front of an authorized authority. So, who is the authorized authority here? In this case, so who is the authorized authority in this case? So, here also it will be appointed by the Election Commission of India. So, okay, so who is appoint the authorized authority? So, there they have to subscribe to an oath, same thing, and then they should not hold on to office of profit. So, here also what is office of profit is not defined, but what is the understanding you can have with regard to office of profit? Same thing, that they should not hold on to any executive office, either under the center, state or the local authorities, by a way of which the profit is receivable. So, that would be considered to be an office of profit. Same thing, only thing is instead of Lok Sabha, you can talk of what is called as Rajya Sabha. Clear? Now, once they satisfy all these conditions, they can contest, but here also there is an exception, that there are certain offices which is of executive nature, which may not be considered to be an office of profit. That means those people, even holding their office, they can still contest the election of the vice president. So, what are the exceptions in case of the president that you have seen? The office of president, in case of president, what are the options? Vice president, governor, ministers in case of center and state, and then the office of the president also. We have seen 4 things: the office of the president, vice president, office of the governors, and the ministers in case of center and the states. All those 4 exceptions are given here as well. So, you can ask me whether a president will contest the election of a vice president. That is up to him to decide, but the constitution allows for all these things. Okay. So, there also, here also the exceptions include office of the president, vice president, governors of the states, and the ministers, both the center and the states. These officers would not be considered to be office of, and they can contest the election. Is that clear to all of you as to what is the qualification? Here also the same thing. His conditions, you will understand that his salary allowances, all those things will be determined by an act of parliament. And same thing, he a member of parliament, if he or she contests elections of the office of the vice president, they cease to be a member of parliament of the state legislature. So, all those things are almost the same.
So, now let us come to understand as to what are all the ways by which the vacancy can arise to the office of the Vice President, vacancy or absence to the office of the President. So, before I move to this particular area, what is the normal duty of the Vice President of India? He is an ex officio chairman of Rajya Sabha, that is his normal function. But in case if there is a vacancy or an absence to the office of the President, then he also discharges the duties of the President. When he is discharging the duties of the President, then who will discharge the duties of the chairman Rajya Sabha? It is a deputy chairman. Now, the key word here is vacancy or absence. I have already explained the difference, but again let me just reiterate. There is a difference between the word absence and vacancy. Can you just anyone recollect as to what do you understand by absence and vacancy? When it is called as vacancy, when it is called as absence. Say for example, the President dies. There is an absence or there is a vacancy? There is a vacancy. The President is critically ill and he is admitted in the hospital. In that case, what is the case? It is absence. So, try to understand the difference. Somebody is there as a President, but he is not able to perform his duties, then it is absence. But somebody is not there as a President, then it is a vacancy. But as per the Constitution of India, either absence or either vacancy, who will discharge the duties of the President? It is a Vice President. In case of vacancy, try to understand, in case of vacancy, except in case the vacancy is going to arise because of the expiry of the term, in all those cases, who will discharge the duties? It is a Vice President. And how long the Vice President can do the duties? Maximum 6 months. This is a maximum time, not necessarily always 6 months, but within 6 months, the new President has to be elected. But there is no time limit for absence. This is what you will have to understand. So, but if there is an absence to the office of the President, then there is no time limit. So, as long as the President is able to assume the office, who can discharge the duties of the President? It is the Vice President. In fact, in 1960 and 1961, in both the year, Dr. Rajendra Prasad, who was the President of India, is not able to perform his duties. And although he was a President, he was absent from the office. One time, I think he was critically ill, admitted in the hospital. In another time, he has gone for an official visit to some foreign country. So, some duties he was not able to perform. So, in both occasions, he requested the Vice President of India to discharge the duties of the President. So, that is only considered to be what is called as absence. Okay, so that can also be done by the Vice President. But however, when he is discharging duties of the President, he is not supposed to act as the chairman of Rajya Sabha. It is the deputy chairman who will perform the duties of the Rajya. Now, let us try to understand the election of the Vice President. Remaining everything is almost the same. So, in case of the Vice President, how he is elected? In this case also he is elected indirectly. It is the same principle. Indirectly elected, proportional representation by means of single transferal vote, and the voting is by secret ballot. All the things are the same. But however, here you will have to understand that there is a difference in terms of the electoral college. Who is the electoral college in case of the President? Quickly can you recollect? Elected members of both the houses of the Parliament, elected members of legislative assemblies of the state, and then elected members of 2 union territories, National Capital Territory of Delhi and Puducherry. There the idea is someone who is elected as a President should represent the entire nation, but the Vice President does not have to do that, because the duty of the Vice President is only to act as the chairman of Rajya Sabha. So, they thought that the election process should not be as elaborate as that of the President, so we will restrict the electoral college. So, in case of electoral college, it is only the members of the Parliament, there is no representation from the states. And because it is going to be only the members of the Parliament, they did not distinguish between an elected and a nominated member. So, try to remember this. So, in case of election of the Vice President, who constitutes the electoral college? It is the members of the Parliament, which includes both what? Elected as well as nominated members in case of both Lok Sabha as well as Rajya Sabha. Anyways, in case of Lok Sabha, today we do not have nominated members, but in case of Rajya Sabha, do we have nominated members? Yes. So, it includes both the elected as well as the nominated members. And the election is based on the principle of proportional representation by means of single transferal vote, and the voting is by secret ballot. So, here you do not have to remember any of the other things, that is more than sufficient. And of course, you have seen the qualifications also. So, all these things are clear to all of you. Can the Vice President of India, can he be removed from his office? Can he be removed from his office? I am not asking anything about an MP, don't confuse yourself. I am just asking, can the Vice President of India, can he be removed? In fact, the Vice President is not a member of Parliament, don't have that understanding. Although the Vice President acts as the chairman of Rajya Sabha, he is not a member of Rajya Sabha, he is not a member of Parliament. He is only acting as a chairman of Rajya Sabha, that does not make him a member of Parliament. Is the President an integral part of the Parliament? The Parliament in India comprises of what? Can anyone tell me? Parliament, we know it includes Lok Sabha, it includes Rajya Sabha, that is the House of People, the Council of States. Does it also include the President? Parliament as an unit, as an entity, it also includes the President. But that does not make the President as a member of Parliament. Don't have that misunderstanding. So, similarly here, the Vice President is the chairman of Rajya Sabha, does not make him a member of Parliament. He is not a member of Parliament. Okay. Anyways, can the Vice President be removed from his office? Yes, the Vice President can be removed from his office. But there is a slight difference as to how the President can be removed and the Vice President can be removed. Okay, so this is very, very important, which we will subsequently discuss. Okay, so just come to the next part. Term of the Vice President, some factual information, then I will go to all those things. Now, if you see the term of the office of the Vice President, what is the term of the office of the Vice President? Same 5 years. And this 5 years is from the day he assumes the office. Whenever he assumes the office, from that day 5 years. And can he resign at any time? Yes, he can resign at any time. To whom he has to submit the resignation? To the President. The President will submit it to the Vice President if he has to resign, and the Vice President can submit it to the President. And the Vice President can also be removed. The President can also be removed. And what is the majority with which the President can be removed? What is the majority we have seen? So just try to make the differences between the removal process of President and Vice President. Do not get confused. Okay. Okay. While the entire process is almost the same, I will just come to the process a little later. But we have seen that in case of the President removal, who is authority to remove? Parliament. So similarly, in case of the Vice President, who is authority to remove? It is the Parliament. But for the President, there is a ground that is mentioned on which he can be removed from the office. What is the ground on which he can be removed from the office? Violation of the Constitution. And for the Vice President, no explicit ground is mentioned in the Constitution. First difference is similar. In case of Vice President, no explicit ground is mentioned. But who is authority to remove the Vice President? Parliament. Okay, so first thing is, there is a ground that is violation of the Constitution. Here is no such ground when it comes to the Vice. Now the second difference is, in case of the President of India, the removal motion can be introduced in either houses. But in case of the Vice President, it can be introduced only in the Rajya Sabha, not in the Lok Sabha. Where it can be introduced? Only in the Rajya Sabha. There it can be introduced in both houses. And in case of the President, in both the houses it requires special majority. What is that special majority? Not less than 2/3 of the total membership of the house. This is just one type of special majority. Not less than 2/3 of the total membership of the house. But whereas what is the majority in case of the Vice President? In case of the Vice President, is it effective majority or simple majority? How many of you think it is effective majority? How many of you think it is simple majority? In fact, it is both a majority. It requires different majority in different houses. So, it is not the same majority. Okay. So, this is another difference. So, it requires effective majority in the Rajya Sabha and simple majority in the Lok Sabha. So, it has to be first introduced in which house? In the Rajya Sabha. In the Rajya Sabha, it requires effective majority. After it is passed by the Rajya Sabha, it comes to Lok Sabha. In the Lok Sabha, it requires what is called as simple majority. So, who can tell me what is this effective majority? Total membership minus vacancies. That is effective majority. Okay, suppose let us assume the total membership is 245. There is a vacancy of 15. 245 minus 15 is 230. Is that what you mean by effective majority? 2/3 of that is majority. Don't confuse yourself. Let us take it one by one. First, you talked about effective majority. Let us try to understand the effective majority. Suppose let us assume the Lok Sabha, Rajya Sabha, where we need to have the effective majority, is having, let us assume 245 is the membership, and out of the 245, let us assume there are 15 vacancies, and that vacancy is for any reason. It can be because of the death of the members, or the removal of the members, or the disqualification of the members. That is not our concern. But suppose let us assume there are 15 vacancies. So that means 245 is the total membership, 15 vacancies are there. You tell me what is the effective majority in this case. More than? It is very simple. See, try to understand. Always majority means more than 50%. So don't put 2/3 and all those things. I am saying effective majority. For effective majority, you need to first have effective membership. The effective membership is total membership minus vacancies. That means that is coming to 230. Of 230, you calculate the majority. What is the majority of 230? Which is more than 50% means majority. What is the majority of 230? 116. So 116 is the effective majority. So where does the 2/3 all those things come? It does not come. Unless and until it is specifically given in the constitution, you don't add anything. Majority is always more than 50%. That means here the effective majority would be what? 116 based on the example that I have taken. Okay, once it is passed with the effective majority, then it goes to the Lok Sabha. In the Lok Sabha, what is the majority with which it has to be passed? Simple majority. So what is simple majority? It is a majority of members present as well as voting. So in that you need to have a majority. That is basically what is called as simple majority. So all these difference you should know when it comes to the vice president. Alright. So but otherwise here also the same thing. Say for example here also 14 days notice has to be given to the vice president, and in the Rajya Sabha before introducing it, it has to be supported by not less than 1/4 of the members, and then the motion is introduced, taken for discussion, and then it is passed with the effective majority. Then in the Lok Sabha it is passed with simple majority, then he stands removed from his office. Alright. So that is basically that you can understand. And here also, suppose if the vacancy is going to arise because of the expiry of the term of the vice president. What is the term of the vice president? 5 years. The new vice president has to be elected even before that. And if the new vice president is not able to assume the office, then who would continue to be the vice president? It is the existing vice president who would continue to be the vice president. But in all other cases, if there is a vacancy, say for example because of the reasons of death, resignation, removal, otherwise means here also the Supreme Court can declare the election of the vice president to be invalid. In this case also, who is authority to declare the election of the president to be invalid? It is only the Supreme Court. So here also the Supreme Court has got original and exclusive jurisdiction. The only authority is there in the hands of the Supreme Court. So in all these cases, suppose if the vacancy arises for so and so reason, that is, I am not talking about expiry, it is because of death, resignation, removal, or otherwise. In all these cases, who will act as the vice president? If the vacancy arises, who will act as the vice president? Nobody will act as the vice president. Nobody is going to act as the vice president, but the deputy chairman will perform the duties of the vice president, which means he will perform the duties of chairman Rajya Sabha. So nobody is going to become the vice president. So try to understand. So in all these cases, it will be done by the deputy chairman. So here, they are not going to become the vice president, but they will perform the duties of chairman Rajya Sabha. Okay, but if the vacancy is going to arise because of the expiry of the term of the president, vice president, then what will happen in this particular case? The new vice president has to be elected even before the expiry of the term. But if the new vice president is not able to assume the office, then who will continue to be the vice president? The outgoing vice president would continue to be the vice president. So try to keep all these things in your mind. So here also, who can challenge the election of the vice president? The the members of the electoral college or any candidate who has contested the election, and they can challenge the election within 30 days. So, in case of the vice president, who is to administer the vote? For the president, who will administer the vote before he assumes the office? The Chief Justice of India or the senior most judge. In case of the vice president, it will be done by the President of India as to administer the vote, and then he will assume the office. From the day he assumed the office, it is normally for a period of 5 years. He performed the duties of the chairman Rajya Sabha. Here also, the constitution does not say anything as to what is the ground on which the election of the vice president can be challenged, but the constitution says what is the ground on which the election of the vice president cannot be challenged. What is the ground on which the election of the vice president cannot be challenged? That there is a vacancy in the electoral college. That is not a ground to challenge. Here also, if the election of the vice president is declared to be invalid, all those prior actions done by the vice president would continue to be what? Would continue to be valid. Okay, so that's the basic understanding that you should have. So, similar to that of the present, everything that you have discussed is similar. So, come to the next topic, that is governor. So, before we move to the governor, come to some practice questions, and then we will go to the governor. Okay. So, come to the practice question, finally we will go to the previous year questions. Okay, so come to this particular question. Consider the following statements regarding the President of India. In case of vacancy to the office of the President, the new President must be elected within a period of 6 months in all cases. Is it true or false? How many of you think it is true? How many of you think it is false? Why false? Because it is saying all cases, and try to remember this in UPSC also, the extreme statements are always wrong. Most of the times, 99% of the times, the extreme statements are wrong. So, here it is making extreme because of all cases. It is not true in all the cases, there is an exception. What is the exception? That if the vacancy is going to arise because of the expiry of the term. When the expiry of the term is there, who will act as the president? The new president has to be elected, but if he is not coming, then the outgoing president, not in all the cases. So, that makes the statement wrong. Any election dispute regarding the election of the president can be challenged only in the Supreme Court. Is it true? Because we have seen that the Supreme Court has got what jurisdiction? Original as well as exclusive jurisdiction. So, this is true. Which of the statements given above are incorrect? What is incorrect? One more. Okay, so have a look into the next two questions. So, have a look into this question. The President of India can be removed by resolution passed by special majority in both the houses of the parliament. Which of the following correctly represents the special majority in this case? Majority of not less than 2/3 of the total membership of the house. Is it the right one? Yes, this is the clear right one. There are different types of special majority in fact. Can anyone recollect any of the other types of special majority? In fact, can anyone tell me what are the different types of majority that is there in the constitution? Simple majority, effective majority, absolute majority, and then special majority. These are the 4 types of majorities in the entire constitution. But there is only one simple majority, there is only one effective majority, there is only one absolute majority. But there are different types of special majority for different purposes. I hope you might know that, but otherwise, whenever I discuss the relevant area, I will discuss about all those things. But in case of the removal of the president, this is the special majority, that is not less than 2/3 of the total membership of the house. Come here. Which of the following is a part of the electoral college of the Vice President of India? Elected members of the parliament? Yes. Elected members of the state legislature? Does the state have representation? No. Nominated members of the parliament? Yes. So, the answer is choose the correct options using the codes given below. What is the answer? 1 and 3. Have a look into the next question. Consider the following statements regarding the removal of the Vice President of India. Okay. Statement 1, he or she is removed. Okay. He or she is removed by a resolution. So, this is a mistake here. He or she is removed by a resolution passed by a special majority in both houses of the parliament. Is that true? No, it is nowhere the special majority is required. The resolution for his or her removal can be introduced in either houses of the parliament. Is that true? Where it can be introduced? Only in the Rajya Sabha. The resolution for his or her removal can be introduced only after giving a 14 days prior notice. That is mandatory. I said that in both the cases 14 days notice is mandatory. So, this is true here. How many of the statements given above are incorrect? 2. Alright. Okay, I have not discussed about the governor, but just try to solve this question. Let me see if you are able to solve this question. Anyways, I will move to the governor, but just take a moment, try to solve this question. Is the audio right now, is it audible to everyone? Okay, is there anyone who can tell the answer? Is a member of parliament or a state legislature cannot be appointed as a governor? Is that true? How many of you think a member of parliament or a member of state legislature cannot be appointed as a governor? Okay, so how many of you think it is true? Alright. Second statement, the salary or the other allowances of the governor is determined by the President of India. That is not true. That is false. Who determines the salary and allowances? It is a parliament. Very good. The parliament has to make a law determine the salary and allowances of the governor. But what if the same person is appointed as a governor for 2 or more states? Then who is going to decide his salary? Will he get 2 salary if he is a governor of 2 states? So, can a person be appointed as a governor for 2 or more states? Is that possible constitutionally? And in that case, will he get 2 salary from both the states? If he is appointed as a governor for 3 states, so in that case, who is going to determine his salary and allowances? His salary is as per the parliament only, but maybe the extra allowances that he is going to get is determined by the president. The president will determine that. But this particular statement is true. There is nothing wrong in that. Sorry, this is wrong. The salary and allowances of the governor is not determined by the president. Who is determining that? It is a parliament by a law. But what about the first statement? A member of parliament or a member of state legislature cannot be appointed as governor. There is no such restriction in the constitution. There is no such restriction. The constitution only says 2 things. He should be a citizen of India, should have completed 35 years of age. There is no other constitutional requirement for someone to be appointed as the governor. In fact, don't confuse with some of the recommendations. So, for example, it is basically a recommendation which is given by Sarkaria Commission, which has recommended a person should not be in active politics, someone to be appointed as a governor, but it is not something which is there in the constitution. Okay, so there is no such restriction. A member of parliament or a member of state legislature cannot be appointed as governor. This is absolutely wrong. They can be appointed as a governor if the president wants to appoint them as the governor. Anyways, we will discuss all those things. So, what is the answer here? Which of the statements given above are incorrect? Both. Which of the statements are incorrect? Both 1 and 2. First of all, for the governor, there is no such condition. But in this case, I have already said a member of parliament or a member of state legislature is not an office of profit. I hope you understand when we discuss that in the president case. Okay, so that is not an office of profit. A legislature is not an office of profit. So, try to go back and see that. Okay, please come to the governor's part. We'll try to understand about the governor as well. Again, a very important topic. So, as per the Constitution of India, there shall be a governor for each state. It is a constitutional mandate. If you see the Constitution, who is the head of the Union Executive? Who is the head of the Union Executive? The President. So, similarly, there is a need for a head of the states. So, who is the head of the state executive? It is the governor who is the head of the state executive. So, you have an union executive, you have a state executive, and this also reflects the federal provisions in the constitution. So, you have a union government, you have a state government. Who is the head of the union government? The president. So, similarly, for every state, you need to have a head of the state executive. Who is the head of the state executive? It is the governor. But we have a parliamentary system, not only at the union level, but also at the state levels. State level also there is an elected government. So, in the state also the governor is merely what? He is a nominal executive. And though he is a nominal executive, where the president is also a nominal executive, but at the union level we have gone for an elections. But at the state level, the governor who is supposed to be the nominal executive, the Constituent Assembly has decided that he shall not be elected, rather he shall be appointed. So, who is going to appoint the governors? It is the president. So, first try to understand, the president is the governor is a nominal executive at the state, but however he is not to be elected, but rather he is to be appointed. The Constituent Assembly could have gone for elections also, for electing the governor, an indirect election. But they have not gone for an election, but rather they have gone for what is called as the appointment process. Can anyone tell me why they have gone for an appointment process? Unlike the president who is elected, the governor is not elected. The governor is just nominated. Sorry, rather appointed, not nominated, appointed. Federal? If it is a truly federal system, I should say that he should be elected. So, for example, in USA, the governors are elected in the respective states. But we have followed the Canadian model, where there also there is a federal system. There are governors in the state, but those governors are nominated. So, why do you think that the Constituent Assembly has chosen for the appointment of the governors? In fact, we are not a true federalism. We are a quasi-federal system. And by appointing the governor, the center can have some element of control over the states. It is not that they want to have the control, but under the Constitution of India, the governor is supposed to perform dual functions, and that is ensured by appointing the governor. Can anyone tell me what are the two functions that the governor is supposed to perform under the Constitution? One is he is head of the state executive. So, he functions as the head of the state executive. That is one of his important functions. What is the other function? He is also what? He is also the, so that is exactly what I was expecting. So, do not use the word agent. The Supreme Court has already said that the governor's office is a constitutional office, and you cannot undermine the office of the governor by calling him as an agent of someone. And the Supreme Court has clearly said that the office of the governor is an independent constitutional office. It is not an office that is attached or subordinate to the office of the president, although he is appointed by the president. So, do not ever use the word agent. He is not agent, but he is supposed to act as a representative of the center's interest in the state. He is supposed to act as a link between the center and the states. So, definitely he is not an agent. And if he is to represent the interest of the center in the states, for which he should be appointed, and the president should have some element of control over the state, and for which the governor has to be appointed. That is why the Constituent Assembly has not followed the model of what is called as election to the governor, rather they have gone for what is called as appointment. What could be the center interest in the states? Because I said two important functions. One, he is a constitutional head of the state, and he is also to take care of the center's interest in the states. So, what is the interest of the center in the states? It is not the interest of the center to control the governance in the state, no, but there has to be some constitutional interest, proper interest of the center in the states. What should be there? First of all, they should see whether the administration of a particular state government is carried out in accordance with the provisions of the constitution. whether the constitutional provisions are carried properly. And you might understand when later I will discuss the center-state relations. Now, there is a lot of division of powers between the center and the states. Although in most of the areas the laws are made by the parliament, who is the implementing authority at the state level? It is a state government. Laws can be made by the parliament, but who is supposed to implement most of these laws? By the state authorities. So, it is the interest of the center to see whether the laws which is made by the parliament are getting implemented in the states. And if it is not getting implemented in the state, who will report about all these things to the center? The governor. Of course, the state government may not report because that is an elected government. So, there has to be some representative of the center to take care of all these things and to report to the center. So, that is the role that is to be done by the governor, for which it is better the governor is appointed, because then the president will have control over the governor, and if he is elected, he may not have control over the governor, and that is the reason the Constituent Assembly has chosen for this. And also at the time of the commencement of the constitution, there was also fear that some of the states might disintegrate from India. So, in order to avoid all those things, they have gone for a model of what is called as appointed governor. Okay. So, this is the background that you should have an idea before I move to the office of the governor. Okay. So, if you look into the constitution, what the constitution says, that there shall be a governor, and if you look into the original constitution, the original constitution did not provide for appointing the same person as a governor for 2 or more states. So, today as per the constitution, there shall be a governor for every state who shall act as the constitutional head of the state. And this constitutional head, is he a real executive or a nominal executive? He is also a nominal executive. There is no doubt, he is also a nominal executive. But if you see the original constitution, there was no provision for the same person to be appointed as a governor for 2 or more states. Is it possible today? That means it has happened by a way of a constitutional amendment. Can anyone tell me which constitutional amendment has allowed for this? Very good. It is the 7th Constitutional Amendment Act 1956. The 7th Constitutional Amendment Act 1956 allowed the same person can be appointed as a governor for 2 or more states. So, can anyone tell me what is the significance of this year 1956? This is when the state reorganization has happened. This is when 14 states and 6 union territories were created. Earlier the classification was Part A, Part B, Part C and Part D states. Now that has gone for 14 states and 6 union territories. New states were created. New states were created, but they are not having new governors. So, they allowed the existing governors to be appointed as governors for 2 or more states. So, to that extent, an amendment was made in the constitution. And he is supposed to normally act as the executive head of the state. And we have already seen that in case of the governor is not elected, but rather he is appointed. And who is the appointing authority? It is the president who is the appointing authority. And this is very, very important. The constitution does not provide any security of tenure to the governor. So, what does it mean? The constitution does not provide any security of tenure to the governor. That means the governor who is appointed by the president can at any time be removed by the president of India. Although what is the term of the governor? 5 years, but not necessarily he may complete his 5 years tenure. So, he can be removed by the president at any point of time. That is why it is said that the governor holds office during the pleasure of the president. So, pleasure of the president means that there is no security of tenure. It is mentioned in the constitution. I do not remember the article, you can verify the constitution. Okay. There is no security of tenure. Okay. So, normally his tenure is 5 years, but he can be removed by the president at any time. So, because he does not have security of tenure and he holds office during the pleasure of the president. And he can also resign from his office anytime, addressing his resignation to whom? To the president of India. To the president of India. So, that is also something that you may have to remember. Okay, now we have learned that the governor does not have security of tenure, he holds office during the pleasure of the president. But can this pressure of the president be misused by the president? Can he arbitrarily exercise his power? Or in other words, if the president is arbitrarily exercising this power, can it be subject to judicial review? That is the question. Is it subject to judicial review if the president is arbitrarily exercising this power? Yes, said the Supreme Court of India in the BP single case. You may just remember this. I don't think a question may come, but in case if it comes, is the power of the president to remove the governor, is it subject to judicial review? Yes, if he is misusing that particular power. So you can ask me how it can be seen or under what circumstances it can be seen that the president is misusing the power, because it is anyways the pleasure of the president. So here the pleasure of the president means, is it the decision of the president or the president has to use this power based on the aid and advice of the Council of Ministers? Or in other words, is it a discretionary power or it is based on the aid and advice of the Council of Ministers? Aid and advice of the Council of Ministers. But can this decision of the president to remove the governor, can it be challenged in a court of law if it is misused? Yes, if it is arbitrarily exercised. One example is, say for example, the center through the president is directing the governor to implement the policies of the center in the state or the ideologies of the central government in the state government, and the governor is not giving such directions to the Council of Ministers, and the president is not happy and hence the governor is removed. Is it an arbitrary exercise or it is a proper use of power? It is an arbitrary exercise of power. The center cannot give any direction to the state to implement their agenda in the state, because the state government is elected by the respective government in the people in the particular state. So according to that, the government will function. So you cannot tell your agenda to be implemented in the state or the policies to be made according to your ideologies. And if the governor is not doing all those things, if the governor is removed for that particular reason, then that is an arbitrary exercise. But otherwise, yes, he is still is not having what is called as security of tenure, and he or she can be removed at the pleasure of the president. But just try to keep this in your mind, this pleasure of the president shall not be misused, and if it is misused or arbitrary exercise, it can be subject to what is called as judicial review. Alright, and in case of governor also, suppose if the term of the governor is over, 5 years term of the governor is over, can he still continue to hold the office? Yes, if the new governor is not yet appointed by the president. Till the time the new governor is appointed, he can continue to hold the office. Okay, in case if the governor suddenly dies in office, then who will act as the governor? Similar to that of the president at the union level, if the governor suddenly dies in office, who would act as the governor? New appointment has not happened. So suppose today in the morning the governor suddenly dies, immediately the president cannot appoint the governor. It may take some time for them to decide. The president cannot act as the governor, that is not possible. Who will act as the governor? No one will act as a governor. The state cannot function without a governor. Now similar to that of the president, all the names or all the actions taken in the center is taken in the name of the president. Similarly, all the actions which is taken in the state are all taken in the name of the governor. So you need to have a governor. So what is a contingency plan and who decides this contingency plan? In case of the president, so what is a contingency plan? Vice president. So is there anyone similar to that of that in the states? No, you don't have anyone in the states. So if the vice president is not there, then the Chief Justice of India, but you have a Chief Justice of a High Court. So what is the contingency plan? The Chief Justice of the concerned High Court. And in case if the Chief Justice of the concerned High Court is not there, then the senior most judge of the High Court. That's the contingency plan. But this contingency plan is not by a law made by the parliament. This contingency plan is made by the President of India, and the constitution gives a power to the President of India to make this contingency plan, and accordingly the President has already made the contingency plan. So if the governor suddenly dies, who acts as the governor? The Chief Justice of the concerned High Court, and in case if he is not there, then the senior most judge of the concerned High Court. That is what is the contingency plan. Alright, so please come to the qualifications. So if you see, the qualifications are very simple, that he or she should be a citizen of India and he or she should have completed 35 years of age. That is the only qualification, no other qualification is given in case with regard to the Governor, because basically the governor is not elected to go for a elaborate qualification. He is just appointed by the president. Is that clear to all of you? So just try to keep all these things in your mind. Don't get confused that can a member of parliament or a member of state legislature can be appointed. Only these two qualifications. No other restrictions apart from that. So just try to keep this in mind with regard to the qualifications. But there are certain recommendations which has been given by certain commissions, especially some of the commissions like the Sarkaria Commission. I think most of you might have heard about this commission, Sarkaria Commission. What is this commission? Subject matter of this commission? To determine better center-state relationship. They have given a lot of recommendations to improve upon the center-state relationship. Is the role of the governor very essential in improving the center-state relationship? Yes, it is a very important role, the role of the governor. So that is why the Sarkaria Commission has recommended that the governor to be a neutral person. Because if he is not neutral and if he is politically biased, so he can create tensions in the center-state relationship. So one of the recommendation that is given by the Sarkaria Commission is usually a person who is not politically active to be appointed as the governor, who is retired from active politics. So don't confuse that with the constitutional provisions. See whether it is asking for a recommendation or it is generally asking for a constitutional provisions. Okay. So just try to keep that in mind. Okay. So come to the conditions of office. What is the difference between qualifications and conditions? Again here, qualifications is for appointment and conditions is to continue in the office once he is appointed as a governor. So there are some conditions that you may have to remember, but with regard to qualifications, only two qualifications. What are they? Citizen and not less than 35 years of age. But conditions of office. What are the conditions of office? He should not be a member of parliament or a state legislature. So now the question is try to understand. Can a member of parliament or a state legislature be appointed as a governor? Yes, he can be appointed as a governor, but once he is appointed as a governor, he cannot continue to be a member of parliament or a state legislature. Now, what is the question we are saying? Can he be appointed as a governor? Hey, can he be appointed as a governor? Yes, because there is no such qualifications, but it is only the conditions. And also, once he is appointed as a governor, can he occupy any of the other office of profit? No, apart from the office of governor, he cannot hold on to any other office of profit. And where this office of profit is defined? Is it defined in the constitution? It is only through the Supreme Court interpretation. And what is this office of profit? Any executive office either under the center, state or local authority by a way of which profit is receivable, then that is office of profit. So a governor cannot occupy any of the other office of profit apart from the office of the governor. And he is entitled for official residence. What is official residence of governor? Governor's office, which is called as Raj Bhavan. And in case of the president, it is called as Rashtrapati Bhavan. So can the president and governor stay outside his official residence? They say that I don't like this official residence, I want to stay in my own private residence. See, that is a condition of their office. They have to stay only in the official residence because it is related to their security. It is related to discharge of many of their administrative functions. Of course, when they go for trip and all those things, that is okay, but otherwise they have to stay in their official residence. And they are entitled for emoluments as determined by the parliament. So who will determine the salary of the governor? Parliament. But if the same person is appointed as a governor for 2 or more states, now in that particular case, the salary will be as per the law made by the parliament, but he may get some extra allowances. Say for example, he may have to travel and all those things. So some extra allowances and emoluments may be given. So who will determine what extra he or she shall get? It is decided by the president, by a presidential order. But who will bear those expenses? Is it the center or the states? The respective states have to bear it as decided by the president. But who will decide that? It is the president who will decide that. And one constitutional requirement is also, his emolument shall not be diminished during his term of office. Can it be increased? It can be increased but not decreased. The same person can be appointed as a governor for 2 or more states. Can he be appointed, same person be appointed as a governor for 3 states? Yes, it can be more than 2 states also. There is no restriction as to how many states a same person can be appointed as governor. So, the governor also, before he assumes the office, he shall be administered a oath. Who shall administer his oath? Chief Justice of the concerned High Court. In the absence of the Chief Justice, the senior most judge of the High Court concerned may uh, perform his oaths. So, in case if the governor is not there, then what is the contingency? Who will act as the governor? The Chief Justice of the concerned High Court. In his absence, the senior most judge of the High Court. So, who has prepared this contingency plan? It is the President. The Constitution authorizes the President to determine this contingency plan. Is that clear to all of you? Alright. So, let us see, is there anything related to the governor? So, these are all very important constitutional provisions you may have to keep in your mind. Okay, so we are almost done with the governor. So, we will move to the next topic, that is the comparison of the President and governor. It will take me some time. We will try to discuss all those things. There are few more things I will have to discuss about the President in terms of their powers and functions, but I will discuss that when I take up the Parliament part, which is more relevant here. But with regard to this, you should have a conceptual clarity. Just go through your notes for a couple of minutes. See if you have any doubts before I move to the next area. Just go through it very quickly. Administration, administering the oath. Administering the oath is, suppose say for example, it is for the President to administer the oath, and subscribing the oath is from the point of view of the person who is subscribing to the oath. Say for example, first I will read it out, the other person has to reread it. So, for me it is administering the oath, for that particular person he is subscribing to the oath. Do you understand the meaning from what I say? So, for example, the President has to administer the oath to, say, when he appoints a Chief Justice of India, and for the Chief Justice of India he has to subscribe to that oath. So, that is from who is doing that. Okay, can the Speaker reject the impeachment motion? In fact, if you look into the Constitution, whatever motion that has to be introduced in the either houses of the Parliament or the state legislature, the Speaker has a complete authority with regard to that. So, it is not that somebody wanted to introduce a particular motion, that it has to be definitely accepted, because who is the ultimate authority to reject or to accept a motion? It is the presiding officers. There is nothing specifically given in the Constitution, so it is ultimately the discretion of the presiding officer. So, that can also be rejected. But although we do not have a president, but when I will take up, say let us assume the removal of the judges of the Supreme Court, and for which also the motion has to be introduced in the Parliament, which has been rejected by the presiding officers. So, it is a discretion of the presiding officers. The Speaker will not vote in the first instance, which I will discuss when I take up the Speaker. There are certain things which we will take up later. To answer your question, he does not vote in the first instance. Not only in this particular case, in any of the matter that is put to vote in the Parliament, in the Lok Sabha, the Speaker shall not vote in the first instance. Okay. If you don't mind, can you ask in English? I cannot comprehend fully Hindi. So, how we can lose both? So, it is very normal that if he is a governor who is also appointed as a governor of another state, and if he is removed as a governor of one state, then he will continue to be the governor of the other state, unless and until he is removed from both the states. So, it depends upon what type of order is passed by the president. Suppose if the president is not happy with the governor, then it is most likely he will be removed as a governor for both the states. And it is not that he is not happy with, he is unhappy with the governor, but he was given an additional responsibility, and if he is relieved of that responsibility, they may appoint another governor. So, only from the state where he is taken away, he will not have the authority. Otherwise, he will continue to be the governor of states. President. So, whenever we talk of the removal of the governor, it can be done only by the president. Why this confusion? Did I say states? Okay, did you ask regarding the states? I understood his question is basically, can the president remove him as a governor from one particular state if he is appointed as a governor for 2 or more states. Is that not the question? The states have no power. You don't have to have such out. The states have no power with regard to the governor. Hmm. 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 Repeat your question. See, the Election Commission of India will come into picture before contesting the election. At the time of filing the nomination paper is what is the role of the Election Commission of India. When you talk of subscribing to an oath after you get elected, then it will be done by a different authority. So, for the president it is the Chief Justice of India, for the vice president it is the president. So, that is after getting elected. So, at the time of filing the nomination it is by the Election Commission of India or the officers appointed by the Election Commission. Yes, that is a constitutional requirement. That is one of the qualifications that you have been discussing. Understood? So, once you get elected, then it is by a different authority. So, who has to administer the vote. Any questions from the online students? Alright, so if the questions are not there, come we will move to the next thing. Okay, now I just want to make a comparison between the president and the governor. I know that I have not elaborately gone into their powers and functions, which I will subsequently discuss. But I just want to ask this particular question. Between the governor and the president, whom do you think has got more discretionary powers? Now, in both the cases, they are merely a nominal executive, no doubt. In both the cases, they are not real executives. But between them, whom do you think has got more discretionary powers? And I will further classify this discretionary powers as what is called as constitutional discretion and what is called as situational discretion. Okay, now for time being you do not have to worry about constitutional discretion and situational discretion, but just tell me who has got more discretionary powers. In general, discretionary power means acting on their own. That is what is discretion. But what do I mean by constitutional discretion is, the constitution itself is giving that discretion by explicitly in some article or some provision is giving the discretionary power. That is constitutional discretion. Situational discretion means probably there is a grey area. The constitution does not explicitly say something and by virtue of which they are exercising these discretions. That is probably what is called a situational discretion, for which I will also give the example. For time being, you try to understand. Discretion means they act on their own, which is explicitly mentioned in the constitution, constitutional discretion. Something is not explicitly mentioned and because there is a vacuum or there is some element of ambiguity in the words in the constitution, because of which they continue to exercise certain discretion, or there are some conventional practice by which they continue to exercise some discretion. These are all situational discretion. Whenever such a situation arises, they exercise these discretion. Anyways, between the president and the governor, who has got more discretionary powers? Is it the president or the governor? How many of you think it is the governor? Anyways, the governor is not the highest authority, the president is the highest authority. So, who should have more discretionary powers? And as per the constitution, who is having more discretionary powers? It is the president or the governor? It is the governor who has got more discretionary powers and the constitution is designed in such a way. The constitution designed in such a way, more discretionary powers to the governor means who is appointing the governor? The president, and through the governor they can have more control over the states. But whereas at the union level the president does not have the discretionary powers, it is the real executive is the prime minister. Similarly, same is the case at the state level also. But giving discretionary power means it is a way by which the center can have control over the states through the office of the governor. So, who is having more discretionary powers? It is the governor. And what is the article do you think that is giving more discretionary powers? Without going into any specific article, a general article for which We will have to remember the difference between Article 74 and Article 163 in the Constitution. That is the crux of understanding the position of governor and the president in the Constitution of India. Can anyone recollect what is Article 74 of the Constitution? Very good. So, Article 74 of the Constitution is saying that there shall be a Prime Minister who is heading the Council of Ministers to aid and advise the President, and the President shall act in accordance with the aid and advice of the Council of Ministers. In fact, if you see the original Constitution says, before the 42nd Constitutional Amendment Act, it says that there shall be a Council of Ministers to advise the President. But the question is whether such an advice is binding upon the President is not very clear. It is only saying that there shall be a Council of Ministers to advise the President. Now, some of the President has become very active. In fact, Dr. Rajendra Prasad, many times he was not listening to the aid and advice which is given by the Council of Ministers, and he openly said that their advice is not binding to me because it is not explicitly mentioned in the Constitution. Then the matter has to go to the courts, and the courts have clarified this, and the courts have clarified that whatever is aid and advice which is given by the Council of Ministers is binding upon the President. Because the kind of parliamentary democracy that we follow is modeled on what lines? Is modeled on what lines? Modeled on the lines of parliamentary system in United Kingdom. Although we have our own differences, but it is modeled on the lines of what? Parliamentary system in United Kingdom. The only difference is India is a republic, they are a monarch. Instead of the president, they have a king or a queen. And the advice which is given by the Council of Ministers is binding upon the monarch. So, similarly here, instead of the monarch, we have here what is called as a president. And the advice that is given by the Council of Ministers is binding upon it. And what was said by the Supreme Court in 1974 in a case which is called as a Samsher Singh case? You do not have to remember the case. Now, 1974, the Supreme Court made it very clear that the President is bound by the aid and advice of the Council of Ministers. What was said by the court was explicitly put in the Constitution by the 42nd Constitutional Amendment Act in 1976 by the Indira Gandhi government during the emergency time. The Constitution was amended, and they categorically said that there shall be a Council of Ministers to aid and advise the President, and the President shall act in accordance with such advice. The President cannot act contrary. And before 42nd Constitutional Amendment Act 1976, it was not explicitly there. So, now explicitly it has been put in the Constitution that the President is bound to act as what? Only as a nominal executive. And who is supposed to give the advice to the President? It is the Council of Ministers, and that is binding upon the President. So, this is one thing. So, exactly this is what is the difference that you have to understand. While by the 42nd Constitutional Amendment Act 1976, Article 74 is saying that there shall be a Council of Ministers to advise the President, and the President shall act in accordance with such aid and advice. But whereas the corresponding article to the Governor, do you know what is the corresponding article for the Governor? It is Article 163. If you go and read Article 163, you will understand that there shall be a Council of Ministers headed by the Chief Minister to advise the Governor, and there is nothing which is making those advice binding upon the Governor. So, no such constitutional amendment has happened to Article 163 in the Constitution. Article 163 is saying that there shall be a Council of Ministers headed by the Chief Ministers to advise the Governor, and the Governor to act in accordance with such advice. In fact, the word shall and all those things are not there. The Governor to act in accordance with such advice, except in those areas where he can act in his own discretion. So, that is the difference between Article 163 and Article 74 of the Constitution. Let me just repeat it once again, just listen to me. Whereas Article 74 is saying whatever is the advice that is given by the Council of Ministers is binding upon the President, because it is saying that the President shall act. But whereas Article 163 is saying that there shall be a Council of Ministers to advise the Governor, except in those areas where the Governor can act in his discretion. In other areas, he shall act in accordance with the aid and advice of the Council of Ministers. That means Article 163 is trying to give some explicit discretionary powers to the governor, because the governor is bound by the aid and advice of the Council of Ministers except in those areas where he can act in his discretion. There is no such expression in Article 74 except in those areas where the president can act in his discretion. But for the governor, it is saying except in those areas where he can act in his discretion. So that means the governor has some explicit discretionary power under the constitution, which may not be there as wide as that of the governor to the president. Okay, now just think for the governor, what are the explicit discretionary powers? What are the areas on which he can act in his own discretion? Because in Article 74, there is no such expression except in those areas where the president can act in his discretion. But in Article 163, it is saying except in those areas where the governor can act in his discretion. Is there any provision in the constitution which gives explicit discretionary power to the governor where he can act in his own discretion? That is not explicitly mentioned in the constitution. Whatever you are saying is right. Who said that? That is right, but it is not explicitly mentioned anywhere. So I said that again the discretionary powers are something which is called as constitutional and situational. So whatever you are talking is a situational discretion. It is not explicitly mentioned in the constitution. Is there anything explicitly mentioned in the constitution which gives the governor the discretionary power? Very good. Article 356 of the constitution is giving him the discretionary power. Under Article 356, can he recommend the president to impose a president rule? In fact, no council of ministers, the chief minister will advise the governor to send a report to the president to impose president rule in the state. That is not going to happen. So that is a discretionary power of whom? Discretionary power of the governor. Okay. One is that Article 200, does anyone know what is Article 200? The governor has a discretionary power to reserve any bill for the consideration of the president. He does not have to follow the aid and advice of the council of ministers. It is his discretionary power to reserve any bill for the consideration of the president whenever a bill is presented to the governor. These are all explicit discretionary power, but constitutional discretion in case of the governors. But such discretionary powers are not there to the president. That is, constitutionally so much discretionary power is not given to the president. So, but the president also has some discretionary power which is there in the constitution. But who has got more constitutional discretion? The governor. So, but if you ask me one constitutional discretion of the president, now just come to the 42nd Constitutional Amendment Act. What is the Constitutional Amendment Act? 42nd Constitutional Amendment Act is making sure that whatever is aid and advice which is given by the Council of Ministers is binding upon the president. But that on top of that, another constitutional amendment was made, the 44th Constitutional Amendment Act in 1970. So this was done by the Congress party, and post the emergency was over, the Janata party came to power. They undone a lot of provisions in the constitution which was made by the Congress party. The Janata party in 1978 made the 44th Constitutional Amendment Act that again amended this Article 74, and by amending Article 74 they made one more change. While the 42nd Constitutional Amendment Act made sure whatever is advice that is given by the Council of Ministers is binding upon the president, but whereas the 44th Constitutional Amendment Act said whatever advice which is given by the president has a power to send it for reconsideration once. One time he can send it for the reconsideration of the for the Council of Ministers. And if the Council of Ministers again send that advice back, then it is binding upon you. So that is given by the 44th Constitutional Amendment Act. So today, tell me, the power of the president under the constitution, whenever an advice is given to him, can he send that advice for reconsideration? How many times he can send that for reconsideration? Once, and that is his discretionary power. That is his constitutional discretion. So this constitutional discretion is there to the president. But however, apart from this, not much discretionary power is given to the president constitutionally. But for the governor, a lot of discretionary powers is given. So who is having more constitutional discretion? It is the governor. But both the president and the governor can exercise certain situational discretions. Now, what do you understand by situational discretion? It is not explicitly mentioned in the constitution, and because there is no clarity in the constitution, under certain situations they can exercise situational discretion. For example, both in case of the president as well as in case of the governor, Whenever the elections are over and then there is no party which is having a clear majority, or say let us assume there is something which is called as hung parliament or a hung state legislature. I hope you understand the meaning of hung parliament or hung state legislature. Everyone knows the meaning of hung parliament or hung state legislature. Hung parliament or hung state legislature is a situation that no clear majority is there for a particular party or for a coalition of parties. Nobody is able to form the government. Under such a situation, then it is a discretionary power of the president to appoint the prime minister, and it is a discretionary power of the governor to appoint the chief minister. Otherwise, what is a convention? Even the constitution does not say who is to be appointed as a prime minister or the chief minister. But otherwise, there is a constitutional convention that we follow. So, what is a convention we normally follow when somebody is having the majority? The leader of the largest party or the leader of the largest coalition party is appointed. But when nobody is having a clear majority, then it is a situational discretion of whom? The president and the governors respectively. But it does not mean that once somebody is appointed as a prime minister, he can continue the government. The president will appoint him as a prime minister, will give him some time to prove the majority, and within the specified time they have to prove the majority. Same is the case with the chief ministers also. So, this is a situational discretion when there is a hung parliament or a hung assembly. Okay, so what if the prime minister suddenly dies? Who will be usually appointed as the new prime minister? Suppose let us assume the term of the Lok Sabha is not over. There is another 3 years for the term of the Lok Sabha to get completed, but after 2 years the prime minister suddenly dies. Then in that particular case, who will be appointed as the new prime minister? The president will appoint, but who will appoint? Who will be appointed? Of course, the leader of the party. The party has to unanimously elect a leader, and if there is no unanimity, because everybody now wanted to become leader, there is no second line succession. Suppose let us assume they see an opportunity for everybody to become a leader, and then everybody is trying to become the prime minister, and there is no clear choice. In that case also, who can appoint the prime minister? The president. It becomes the discretionary power of the president if there is no obvious successor. In fact, do you know, after the death of Prime Minister Indira Gandhi, Mr. Rajiv Gandhi was appointed as the prime minister, where at that point of time the president has exercised his discretion. He was not the obvious choice, but there was no obvious choice, and hence who has exercised the discretion? The president has exercised his discretion, appointed Rajiv Gandhi as the prime minister. At that point of time, Rajiv Gandhi was not even a member of parliament. He is not even a minister. He was completely outside, and he was appointed as the prime minister. So, this also gives one more question. Can someone who is not a member of parliament, can they be appointed as a minister? Yes. And how long they can be appointed as a minister? 6 months. Okay, say suppose let us assume somebody who is 18 years of age, who is eligible to vote because he is 18 years of age, or he is 18 years of age, but he is not a member of parliament. Can he be appointed as a minister? Yes or no? Somebody who is 18 years of age, somebody who is 20 years of age, can he be appointed as a minister? He is eligible to vote. Can he be appointed as a minister for 6 months? For 6 months he can be. How many of you think he or she can be appointed for 6 months? How many of you think no? Alright, we will come back to this particular area later. Just think about it, okay? Whether he can be appointed or not. So, this is what is the basic understanding we should have. I will just complete one more area, then we will try to do some questions, and then probably we will come back to the other areas. Okay, so before I complete the president, so is it clear to all of you the discretionary powers? What is constitutional, situational, who is having more discretion, what is difference between article 163, article 74, and one more important article that you will have to remember is the essence of article 77 and article 166. Now, what is article 77 of the constitution is saying? Article 77 of the constitution is saying it is the president who will determine the transaction of business rules of the central government. And similarly, who will determine the transaction of business rules for the state government? It is the governor. So, suppose if a question comes, the president is the authority to determine the transaction of business rules, that is true. Although it is not his discretionary power, he has to do it on the aid and advice of whom? The Council of Ministers. So is the case with the governor also. But the constitution is giving that authority to whom? To the president and the governor. But can anyone tell me what does it mean by transaction of business rules? The president is the one who has to determine the transaction of business rules for the union government. The governor is authority to determine the transaction of business rules for the state government. What does this mean? When you talk of transaction of business rules, what does it mean by transaction of business rules? Transaction of business rules is basically, it is the president for him to determine how to organize the business of the union government. When I say how to organize the business of the union government, it means how many ministries has to be there, how many departments has to be there. So, who will determine the number of ministries in the union government? Today, there are number of ministries in the union government. So, you have to, someone has to decide about all those things. And within the ministry, there are multiple departments. So, how many departments are there? Who is authority in every department to authenticate various files? How the decisions are to be made? And who is authority to implement those decisions? For everything, appropriate authority has to be decided. So, who will determine all these authorities? It is the president for the union government. And similarly, for the state government, who will do that? It is the governor. But however, in both the cases, it is not their discretionary power. It has to be done on the aid and advice of the Council of Ministers. So, basically, it is the Council of Ministers who will determine, but done in the name of whom? In the name of the president and the governors. Alright. So, this is the basic understanding you should have till this point of time. So, now we will move to the next part in terms of their powers and functions, that is the pardoning powers of the president and the governors. So, just listen to me. So, most of you might have an understanding as to what is the pardoning powers of the president under Article 72, and similarly for the governor under Article 161 of the Constitution. Can someone tell me what does it mean by the pardoning powers? What do you understand by pardoning powers, and when this power can be exercised? One of you? Anyone? Okay. Before understanding what is pardoning powers, my question is when this power can be exercised. To try to understand the pardoning powers both in case of the president as well as in case of the governor can be exercised when they have exhausted all the judicial remedies. So, this has to be very clear. So, when it is the matter is sub judice or when there is a judicial remedy that is available, they cannot seek these powers. Now, once all the judicial remedy is over, then only they can seek for what is called as a pardoning powers, either to the president or to the governor under Article 161 of the Constitution and to the president under Article 72. So, if we talk of the pardoning powers under Article 72, that is the highest power the president can exercise, but the president can exercise other powers also. What are the other powers that can be exercised by the president under Article 72? One is he can exercise pardoning, he can pardon a punishment, he can commute a punishment, he can remit a punishment, he can reprieve, and he can also respite. So, what is the difference between all those things? So, let us take it one by one. Similar powers can also be exercised by the governor under Article 161. So, there are few important differences that you have to understand, which I will subsequently discuss. So, first is the pardoning power. What do you understand by pardoning power? That means completely setting an individual free of all the punishments and the consequences that may arise out of the punishment. So, completely setting an individual free, that is basically what is called as pardoning. That means there is no liability to the individual after that. Say for example, suppose let us assume somebody is convicted for 5 years of imprisonment, let us assume, and suppose if a member of parliament, let us assume a member of parliament is convicted for 5 years, That means he has to go to jail for 5 years, and after he complete the term of 5 years, he may not be able to contest election for another 6 years. That is a consequence of that particular punishment. That is what is the law of the land today. Suppose if this is pardoned by the President of India, that means he will be immediately set free from the jail and he can also contest the election. That means he is completely free of any form of punishments and the subsequent consequences of this punishment. That is the highest power that can be exercised by the President. Pardoning means completely setting an individual free. Now the second thing is commutation. What do you understand by commutation? Commutation is usually reduction in punishment, but with a change in character. And with a change in character, usually to the benefit of the person who is imprisoned or person who is punished. Say for example, it is usually reduction in punishment from a higher punishment to a lower punishment. Say for example, death punishment to life imprisonment to 10 years of imprisonment, whatever it is. There is always a change in the character, or there is reduction in the punishment. Now the third thing is remission. What do you understand by remission? Remission means that there is a reduction in the punishment without change in the character. So there will be reduction in the punishment, but there will not be change in the character. Say for example, from 10 years of imprisonment, it may go to 5 years of imprisonment. But if you see the imprisonment, when somebody is imprisoned, there are two forms of imprisonment, for the rigorous imprisonment or a simple imprisonment. So when the remission is happening formally, for example, from 5 years of rigorous imprisonment, 10 years of rigorous imprisonment to 5 years of rigorous imprisonment, the punishment is getting reduced, but there is no change in the character. That is basically what is called as remission. And then next thing is what is called as respite. What do you understand by respite? Respite is a temporary relief. It is not a permanent relief, it is a temporary relief, considering certain special circumstances. So for example, somebody who is found guilty, somebody who is punished, they may suffer from a physical disability in the jail, or they may undergo what is called as pregnancy and all those things. So during such time, a temporary relief may be given to one individual. That is basically what is called as respite. And what is reprieve? Reprieve is a stay on the imposition of the punishment. So normally the President may impose what is called as reprieve to stay the imposition of the punishment. This is basically what is called as reprieve. Normally this happens in case of what is called as capital punishment. So for example, whenever an individual is given a capital punishment, what do you understand by capital punishment? Death penalty. So whenever a death penalty is given, it is very likely they will apply for a mercy petition to the President. And when they apply a mercy petition to the President may not dispose that petition immediately. There are times where the President take 10 years to give an order on that particular petition. In the meantime, what the President will do? He will impose what is called as reprieve. That means he will continue to be in jail, but the capital punishment will not be executed. There is a temporary stay on the execution of the punishment. So till the time it is there. So this is basically what is called as reprieve. Is that clear to all of you? So these are the different types of different types of powers which can be exercised both by the President as well as the Governor. But now the question is there any doubt? But now the question is, what are the circumstances under which he can exercise these powers, or what are the nature of cases under which he can exercise these powers, that is the President and the Governor. First let us discuss about the President and then we will go to the Governor. So while both the President and the Governor can exercise all these types of powers, that is pardon, commutation, remit or remission, reprieve and respite. But what are the nature of cases in which the President can exercise all these powers? And then subsequently the Supreme Court has given some clarity on all these powers as to how they can be exercised. I will come to that particular area. First is in which or what nature of cases the President can exercise all these powers. First and foremost, the President has the power to exercise all these things in case of what is called as court martial. If the punishment is given by a process of court martial, who has the power to exercise all these things? President. So what do you understand by court martial? Is any of the punishment is given through what is called as a court, is done through what is called as an army act or through an army law, through a military court. So who is giving this punishment to the individuals? It is a military court through a military law, and that particular process is what is called as court martial. Now try to understand, when I talk of court martial, the procedure may be entirely different than that of a normal court. because everything is done by a military court according to the military laws and according to the military procedure. But ultimately, once a punishment is given by this military court, so who can take up these cases for pardoning, or to whom the affected individuals can file the petition? It is only to the President of India. So, court martial, they can go only to the President, irrespective of the punishment. Whatever is the punishment that is given, they can apply for a mercy petition to the President. Now, 1 in case of court martial, 2 in case of what is called as death sentence. Whenever an individual is given a death sentence, then also they can apply a mercy petition to whom? Mercy petition to the President of India. But here you will have to understand one thing. The death punishment can be given not randomly. Say for example, the judges cannot randomly give the death punishment. The judges can prescribe punishment or award punishment as per the law of the land. That means the law has to allow for capital punishment. Only if the law allows for the capital punishment, then only the judges can give the capital punishment. Say for example, in certain cases of rape, today death punishment is allowed. So according to which the death punishment can be given, or if it satisfies the principle of what is called as rarest of rare doctrine, then the death punishment can be given by the judges in the courts. Now the laws can be made both by the parliament as well as the state legislature, and both the laws can prescribe what is called as death punishment. So in both the cases where they can go, whether it is based on the law made by the parliament or the law made by the state legislature, in both the cases if the death punishment is given and if all the judicial remedies has been exhausted till the Supreme Court, so where they can apply to the mercy petition? To the President of India. So there they can go to the President. So in case of court martial, where they can go? President. In case if the capital punishment is given, irrespective of the law made by the parliament or the law made by the state legislature, in case of capital punishment, where they can apply for the mercy petition? President. Now the third category is, now it is neither court martial nor a capital punishment, but any of the other punishments. It is not a punishment through, I am repeating it, it is not a punishment through court martial nor it is a capital punishment, but say let us assume life imprisonment, not through court martial, it is not a capital punishment. Life imprisonment is given by the ordinary court of law. Say let us assume the Supreme Court has given life imprisonment. Supreme Court is not a court martial, it is not a military court, and it is not a capital punishment. Or it can be any of the other punishment which is given and all the judicial remedy has been exhausted. In this case also they can go to the President of India, but provided it is based on the law that is made by the parliament. So based on which law the punishment should have been given? Based on the law made by the parliament, or where the executive power of the union extends. In all these cases where they can apply for the mercy petition? To the President of India. I am just repeating it again. What are the nature of cases? You can go to the President. So first case is what? Court martial. Second case, where there is a capital punishment. There it does not matter whether it is based on the law made by the parliament or state legislature. Where they can go? They can go to the President. In all other cases where the punishment is given based on the law made by the parliament, then also where they can go? They can go to the President. Suppose let us assume an individual is given 10 years of punishment by the Supreme Court. He has exhausted all the remedies, but that 10 years of punishment is based on the law made by state of Haryana. Suppose let us assume. Can he go to the President for the pardoning powers? Can he apply to the President? Yes or no? See, listen to the case again carefully. An individual is given 10 years of punishment based on the law that is made by the state legislature of Haryana. And what is the punishment that is given by the court in this case? The highest court is 10 years of imprisonment. It is not a capital punishment, it is not a court martial. The executive power of the union does not extend, it is the executive power of the state. Can this individual apply for a mercy petition to the President of India? He can never go to the President in this particular case. He can only go to the governor in this case. There is no possibility he can go to the President. So, because the governor also has certain powers. So, just try to understand. What are all the cases? It is only the exclusive power of the President. When I say the exclusive power of the President will have exclusive power with regard to what? Court martial. The President have exclusive power with regard to wherever the executive power of the union extends. In all those cases, it is exclusive power of the President. But when somebody is punished based on the law made by the state legislature, it does not go to the President. Where it will go? it will go to the governor unless and until it is a capital punishment. In case of capital punishment, it can go to the president. Just try to remember this. I am not done with the governorate, but I will just come back to it. So far clear to all of you? Do you want me to repeat this one more time? How many of you want me to repeat this? Please raise your hand fully. Okay, listen to me very carefully. This can be very confusing if you do not properly understand it. Have you understood the different types of powers? That is same for both the president and the governor. The meaning of pardoning is the same. Article 72 is giving set of powers to the president. Article 161 is giving set of powers to the governor. So that is quite clear. And all these powers can be exercised only after all the judicial remedy is exhausted. That means after all the remedy and all the options are exhausted in the Supreme Court, then only they can go for this pardoning powers. Okay, now coming to the pardoning powers of the president. So what are the powers of the president? All the powers of the president, where he can exercise, in which nature of cases he can exercise. One, in case of what is called as court martial. In case of court martial, whatever may be the punishment that is given, where they can go, the affected individual, only to the president. That is not the power of the governor. The second is death penalty, capital punishment. In case of death penalty, they can go to the president. Doesn't matter what is the law based on which the judiciary has given the capital punishment. Whether it is based on the law made by the parliament or the law made by the state legislature does not matter. Where they can go to the president. Two is over. Now the third thing is, apart from capital punishment and apart from the court martial punishment, if the punishment, any of the other punishment is given, say life imprisonment, 5 years of imprisonment, 10 years of imprisonment, whatever it is, in all these cases also they can go to the president, provided it is based on the law made by the parliament, where the executive power of the union extends. Where the executive power of the union extends? The executive power of the union government will extend in those areas where the parliament has made the law. So if the punishment is based on this law, then where they can go? They can go only to the president. Say for example, somebody is given 10 years of imprisonment based on the Indian Penal Code, IPC, which is now renamed as Bharatiya Nyaya Sanhita. So 10 years of punishment is given. It is neither a capital punishment nor what is called as a court martial. It is through the Supreme Court of India this punishment is given, 10 years of imprisonment. But Bharatiya Nyaya Sanhita is a law enacted by the parliament. So in this case, where the individual can go? He can go to only the president. He cannot go any of the other places. But you know that the criminal law is an item in the concurrent list. So various states can also have their own criminal laws. Suppose let us assume some IPC is there. It is not an Indian penal code. Suppose let us assume the penal code of a respective states. Some states have made some criminal laws because it is an item in the concurrent list. And the punishment is given based on the law made by a particular state legislature. Let us assume the state legislature of Rajasthan. And they have violated a law as per the law made by the state legislature of Rajasthan, where 10 years of imprisonment has been given by the Supreme Court. In this case, where the individual can apply for the mercy petition, he can go only to the governor. He cannot go to the president, because here the executive power of the state extends. The executive power of the union does not extend. So try to listen to me very carefully. In which cases they can go to the president? In cases of court martial, in cases of death punishment, it does not matter whether it is a law based on law made by parliament or state legislature. And then in all other cases where the punishment is neither death nor court martial, in all other cases they can go to the president if the punishment is based on the law made by the parliament. Clear? Now come to the governor, if that is clear. Now coming to the governor has no power with regard to court martial. No power with regard to court martial. So in case of court martial, where they can go? Only to the president. In fact, with regard to court martial, the military laws, it is only the power of the union, only the power of the parliament to make law. So anyways, they can go only to the president. No problem. Now suppose let us assume any of the other punishment, let us not take into consideration right now the capital punishment. Suppose any of the other punishment, say 10 years of imprisonment, life imprisonment, or 5 years of imprisonment, 2 years of imprisonment, whatever it is. If the punishment is based on the law made by the state legislature, then where the mercy petition can go? Only to the governor of the concerned state. So wherever, whichever law has been made, based on whichever law made by state legislature, wherever he is punished based on that particular law, if he is punished, they can make mercy petition to the concerned governor. Clear? Now coming to the death punishment, because the state legislature law can also prescribe death punishment. So now if a capital punishment is given by the court based on the law made by the state legislature, so in that case, can they go to the governor? Can they go to the governor, or it can go only to the president? Okay, so just think about it. Can it go to the governor, or it can go only to the president? So how many of you think it can go to the governor also in this case? President, anyways, it can go. I am not saying that it cannot go to the president. I am talking about law made by the state legislature, but where a punishment is capital punishment. So can it go to the governor? That is my question. So it is very clear after 2021, the Supreme Court of India has held in the Arun Kumar case versus State of Haryana, that in case of capital punishment, suppose if it is based on the law made by the state legislature, the governor has the power to pardon even a capital punishment. So with regard to the death punishment, capital punishment, based on which law? Based on the law made by the state legislature, the governor also has the power to pardon it, including the other powers. So try to understand this. In case of the capital punishment based on the law made by the state legislature, the individual can go to the governor also, the individual can go to the president also. But if the capital punishment is based on the law made by the parliament, where he can go? He can go only to the president. In this case, it cannot come to the governor. So let me just try to understand all these things one by one right now very clearly. Just try to carefully note it down. So first, capital punishment, who has the power? Only the president. And then apart from that, sorry, in case of court martial, not the capital punishment, in case of court martial, who has the power? Only the president. And then capital punishment, for capital punishment, either based on the law made by the parliament or the state legislature, they can go to the president. But if it is based on the law made by the state legislature, they can go to the governor also, including pardoning powers. And then apart from court martial or capital punishment, if any of the other punishment is given, then they have to go to the concerned authority, where if it is a president, if the union power, if it is based on the law made by the parliament, only to the president. If it is based on the law made by the state legislature, only to the governor. This is the basic understanding. Is that clear to all of you? So does the governor has got the pardoning powers? Yes, even with regard to capital punishment, but based on what? Based on the law made by the state legislature. In fact, the Supreme Court categorically said that nothing in the constitution takes away the pardoning powers of the governor, even with regard to the capital punishment, and this power has to be exercised by the governor in order to give effect to the federal principles in the constitution. So the president is the union executive, so is the governor in the state executive. According to your law, if a capital punishment is given, you can take up the petitions and including the pardoning powers. So this is basically what has been held by the Supreme Court. Is that clear to all of you? It is the petitioner's choice. So normally what they will do is, going to the governor means it is giving an option of again going to the president. So normally they may go to the governor if it is a law based on the state legislature. But if it is a law based on the parliament, only one option, you can go only to the president. So this is understanding this. Is that clear to all of you? It is not binding. The decision of the president is not binding upon the governor, because in both the cases, again the Supreme Court has clarified, it is not the decision of the president or the governor. The president or the governor has to act on the aid and advice of the Council of Ministers, respective Council of Ministers. But however, if the president has already decided, it may have some kind of moral obligations upon the other authorities. So rather they would go to the governor and then go to the president, okay, in this particular case. Alright, so please now come to the questions. Then yes, all these powers are subject to limited judicial review. That is what the Supreme Court of India has said. And what is this limited judicial review? Only the Supreme Court knows it. That means they are subject to judicial review. So basically, where they said that if these powers are exercised with lack of application of mind, or these decisions are taken which are extraneous to the facts of the case, that means the facts is saying that he is completely guilty, he has killed 1,000 people, a terrorist, but the president is pardoning him, then that means it is completely extraneous, the president has not applied his mind, it may be subject to what is called as judicial review. So the very idea of giving these powers to the president and the governor, the idea is because of the fact that there is a possibility of judicial errors to rectify these judicial errors. But if you are randomly and arbitrarily using these powers, then they may be subject to what is called as judicial review. This is what the court has said. Okay, so please come to the questions. Let us see the questions, and then there are few more topics which we will subsequently see, but we will try to cover these questions and then we will move forward. This is something we have done. Okay, so come to the next questions. Okay, so once I am done with this, I am done with, say, probably whatever I want to cover. Remaining things I will cover later, even with regard to the president. So whatever I want to cover with regard to president is done in today's class, and then we are done with the vice president also. Governor, the powers and functions of the president and governor, I will come when I take up the legislature, but whatever I want to cover, that is done. And then the comparison between the president and the governor is done. Their pardoning powers is also done. And the remaining things, say for example, the prime minister and the council of minister, the chief minister and the council of minister, the attorney general and advocate general, maybe I will continue in the next class tomorrow. So now we will just do the questions, and then once I complete all those things, I will take up the previous year questions also, maybe in tomorrow's class, but just go through these questions. We will try to solve these questions. Come to this question. The governor, as per the constitution, should be an outsider, that is, should not be a resident of that particular state when he or she is appointed as the governor. Is that true? There is no such constitutional requirement. It is only a recommendation which is given by the Sarkaria Commission, but constitutionally no such requirement. So even when the question does not explicitly ask the constitution, assume that they are referring to what is called as the constitution. So this is not the case. The governor's salary can be diminished during his term of office by an act of parliament. Can they be diminished? Although it is determined by an act of parliament, even an act of parliament cannot diminish his salary and allowances, not possible. The governor enjoys a fixed term under the constitution. Does he exercise and enjoy fixed term? Although the term is normally 5 years, but he does not exercise what is called as a fixed term. That is, he does not have any security of tenure. That is the understanding we should have. He does not exercise and enjoy fixed tenure because the constitution also says that he holds office during the pleasure of the president. So what is the answer here? None. Come to the next question. The president of India has got more constitutional discretion than the governors of the state. Who is having more constitutional discretion? It is the governors. Can anyone give me a couple of examples or articles? Article 200, very good, which I will discuss elaborately when I take up the legislature part, when I take up the emergency provisions. I will discuss all those things elaborately, but right now have the understanding who is having more constitutional discretion. It is the governor. Well, the president can exercise certain situational discretion, whereas the governors cannot. Both the president and the governor can exercise situational discretion under respective conditions. Which of the statements given above are incorrect? Is it correct or incorrect? The president of India has got more constitution. No, this is also wrong. Okay. So what is the answer here? Both 1 and 2. Okay, come to the next question. Consider the following statements. The governor of a state has constitutional discretion in appointing a minister in the state cabinet, which I have not discussed, but I will discuss through this particular question. The governor of a state, which basically I will discuss when I take up the council of ministers, but anyways. So the governor of a state has constitutional discretion in appointing the ministers in the state cabinet. Is it true? So if he does not have the discretion, then whose advice he will appoint the ministers? It is on the advice of the chief minister. Try to understand. So if the question comes that the governor will appoint the chief minister and the other ministers are appointed by the chief minister, it is wrong. All the ministers are appointed by whom? Only by the governor. But the constitutional convention is that anybody who is the leader of the largest party will be appointed as a chief minister. And based on the advice of the chief minister, the governor will appoint the other ministers. Okay. So the governor of The state has constitutional discretion. He has no constitutional discretion in this regard. It is strictly based on the advice of whom? Advice of the chief minister. The governor of a state is appointed by the president by a warrant under his hand and seal. Is that true? Yes. He is specifically appointed by a warrant under his hand and seal. What does it mean by warrant under his hand and seal? Okay, so I'll just give another example. All the All India services are also appointed by the President of India. Who is appointing authority for IAS officers? For the IPS officers? President of India. In fact, for most of the central government officers, it is the President who is appointing authority for the gazetted post. But there it is not mentioned that the President is appointing by a warrant under his hand and seal. You will see, while the appointing authority for the IAS officers is the President of India, but it is not by a warrant under his hand and seal. But for governor, it is by a warrant under his hand and seal. For the judges of the Supreme Court, it is by a warrant under his hand and seal. So, does it make any difference when you use the word by a warrant under his hand and seal? What difference is that? Removal? So, for the judges, he cannot remove the judges at any time. For the removal of the judges, there is an elaborate process in the constitution. In fact, none of the Supreme Court judges has been removed till this point of time, or the High Court judges are removed till this point of time. There also it is mentioned by a warrant under his hand and seal. That means, yes, very good. That is his exclusive authority. If you see the constitution says that the President is the head of the Union Executive, where he can exercise those powers directly or through his subordinates. Which means the President can delegate some of his functions to the other authorities, his subordinates. So, whenever you talk about the President by a warrant under his hand and seal, these are all functions the President cannot delegate. He has to issue the appointment by himself. That is basically what is called as by a warrant under his hand and seal. But whereas in case of appointment of the IAS officers and IPS officers, although the appointing authority is the President, but he is delegating that power to the Secretary of the concerned department or any of the other authorities, because that is not an appointment by his warrant under his hand and seal. Okay. The governor of a state is appointed by the President by a warrant under his hand and seal. So, that is true here. Which of the statements given above are incorrect? One only. Come here, anyways we have not discussed it, but if you can solve it, you can solve it. Just have a look at it. Anyways, I will solve this question tomorrow after discussing, but you can just read it. I do not think we will be able to pick up a new topic. Is the questions done after this? Do we still have questions? I mean, not the PYQs, these are all practice questions. Two more questions are there, but I think this also we will have to cover it. Okay, so this try to solve it, this particular question, leave that question, come to this particular question. This we have done. Try to solve this question. What is the answer? Fixing the population based on 1971 census in presidential election, making cabinet advice binding upon the president, allowing the president to send the cabinet advice once for reconsideration. Which of the above are part of the 42nd Constitutional Amendment Act 1976? What are all the things which is part of the 42nd Constitutional Amendment Act? UPSC does ask one question about the amendments also, but they do not pick some random amendments, they pick some important amendments. So, 42nd, 44th, 39th probably, and some recent amendments probably, whatever is in the current affairs can also be asked. So, I will just try to cover these things also, but anyway separately I will have one class maybe for 1-2 hours for the amendments, but in between I will try to cover certain amendments. So, is that there in the 42nd Constitutional Amendment Act? This one? Yes. What about this? So, it is part of which constitutional amendment? 44th Constitutional Amendment Act 1970. So, what is the answer here? 1 and 2 only. Okay. So, just go through the couple of other 2 questions also, and if you can solve, we can solve it, otherwise I will discuss that in the next class and then we will try to solve that. So, please write before we wind up the class, just give me a couple of minutes. So, when we will come back tomorrow, I want you to revise all these things first of all, because if you do not revise then you may forget. Your memory is very fresh, take some time, maybe 1 or 2 hours to revise all these things, and also go through all the questions. Just do not skip the questions whatever you have solved, so that you will understand what are all the things that you have learned. So, when you will come back, I will just take up the first thing tomorrow is I will take up the Council of Ministers, that is Prime Minister, Chief Minister, Council of Ministers in both the categories, and then after that the Attorney General and the Advocate General. So, I will do the practice questions, and then I think there are roughly around 20-25 the previous year questions also from these areas, whatever you discussed. I will try to do that also, which will take me say around 1 hour maybe in the next class, or maybe 1.5 hours, and then I will move to the topic of what is called as legislature. So, in this way what we will do is we will go theme by theme. So, you might think there are certain things in the president which has not been covered, do not worry, I will cover that when I take up the legislature. Even then it is not covered, I will do it in certain other parts, because I have my own way of taking all those things. But all that I want you to do is, whether you come read to the class, that is up to you, but at least I want you to revise whatever has happened in the class, that is mandatory if you want to get the full benefit of this particular course. And also try to make note of each and everything that comes out of my mouth, that is very, very important. It is the way that you can understand. I am not saying that you will have to take it elaborately, even by a single hint word, but you should be in a position to recollect it, what you have written it, and understand all the points, whatever has been discussed, alright. So, with that we will wind up the class for today, and tomorrow we will discuss again in the same time, alright. Any questions before we wind up the class? Alright, so then we will wind up the class. Thank you very much.